Committee on Oversight and Government Reform will come to order. Without objection, the Chair is authorized to declare a recess at any time. The title of today's hearing is about the EPA mismanagement. This is the second hearing we've had. We had one back in April. And once again, we find ourselves at a hearing examining the management failures at the EPA. Allegations before us today are disturbing and sound strikingly similar to a hearing this committee held just a few months ago. In April, we discussed Peter Jutro, the former EPA manager who had a history of serial harassment. Mr. Jutro harassed at least 16 women, with 13 of them filing formal complaints of misconduct to management. These reports unfortunately fell on deaf ears. In fact, EPA leadership continued to promote Mr. Jutro even though he continued to harass his female co-workers. The EPA Office of Inspector General launched an investigation in August of 2014 into alleged acts of sexual harassment by Peter Jutro. During the course of its investigation, the EPA OIG corroborated the sexual harassment of a 21-year-old female intern at the Smithsonian and uncovered other allegations of Jutro's sexual harassment of female EPA employees throughout his 31-year career at the agency. Senior officials at the EPA may have known about Mr. Jutro's prior misconduct prior to the intern incident, but it did not take necessary steps to corroborate that information while promoting him to the acting associate administrator position in February of 2014. They failed to contact Mr. Jutro's direct supervisor, who knew of the allegations against Mr. Jutro and verbally counseled him on multiple occasions for inappropriate behavior. When the EPA Inspector General attempted to interview Mr. Jutro a second time, the agency allowed Mr. Jutro to retire, blocking the OIG from pursuing the investigation further. The deep concern here is that people are going to do stupid things. Okay? That's going to happen. We're a very forgiving society. But when you have somebody who repeats this behavior that is absolutely and totally unacceptable and does so time and time again, there need to be consequences, not promotions. And it is of deep concern to this committee, to this Congress, on both sides of the aisle, that when these things are brought forward, that they're dealt with. The situation here we're dealing with here today is another very unfortunate situation, to say the least, of a young woman who is harassed. And then it was compounded by the fact that the people who were trying to investigate it and hold people accountable were retaliated against. So today we are discussing new allegations of sexual harassment along with employee retaliation in EPA's Region 5 Chicago office. Sadly, this incident is almost identical to the Jutro situation. Here, a 24-year-old research fellow is the victim of a sexual harassment by a 62-year-old employee by the name of Paul Bertram. The victim in this case, and I would admonish our members here and the people that are on the panel today, we do not want to refer to this victim by name. She deserves our utmost respect. I do not want you to use her name. Call her the victim, intern X, but we are not to use her name in this hearing here today. We're trying to protect her identity. She deserves better in her young career as she's starting forward. But in her statement, when she put forward what she went through, the way she described it is there was inappropriate, this perpetrator, Mr. Paul Bertram, inappropriately hugged her, rubbed her back, grabbed her, rubbed her hands, touched her knees, kissed her, made suggestive comments, and engaged in unsolicited physical and verbal contact. This happened countless times over a period of years. The consequence, they moved the 62-year-old's cubicle. That was one of the consequences. Unfortunately, he had a history of this. This was not just the first time. This was not just an isolated incident. What we're going to hear today is this had happened several times before. And when it happens, you've got to deal with it and protect, in this case, the young women in the office, because it creates such a toxic environment. The overwhelming majority of people at the EPA, the overwhelming majority of people that work in our federal government, they're good, honest, decent people. They don't do this. But it taints the whole atmosphere. In fact, one of the most toxic environments we have is at the EPA. How ironic. The mission of the EPA is to protect the environment, protect the people. The problem is the EPA doesn't protect its own employees. And we've got good people here today who are in a position to do something about it. They did their work, but then they were retaliated against. That only compounds it and makes it worse. Our witnesses today believe the EPA management in Chicago retaliated against the employees who investigated the victims' accusations of sexual harassment. 3 of these employees are testifying today. 3 of them. This is not just one person saying, oh, I was singled out. 3 of them. And there are more. I applaud them for being brave enough to come before this committee today and to tell their story. Other employees have submitted written testimony, and one passage from Ms. Deborah Lamberti, I hope I pronounced her name properly, is a perfect example of what these employees are facing, but it's so fundamentally wrong at every level. And I read from what she wrote, quote, "Retaliation isn't always loud and full of itself. It can be quiet and chilling, the soul-crushing kind, the kind that leaves you alone in your cubicle in tears in the middle of the day." That is so wrong. We would be deficient in our jobs if we didn't highlight this. We're here to help solve this. We're oversight, but we're also government reform. And if we have to keep doing this, we're going to keep doing it. But if we don't shine a light on it, it isn't going to get solved. Something is wrong when multiple employees come to Congress and attempt to get attention of the EPA management. I would like to enter into the record, I ask unanimous consent to enter into the record a letter from the National Treasury Employees Union, somebody I don't always agree with. On July 1st of 2015, they wrote this letter to myself and Mr. Cummings, the ranking member. I'll read one sentence from it. "Our trust and confidence in the EPA leadership has sunk to an abysmal level, and we respectfully submit to you that more remains to be done in order to correct this unacceptable situation." End quote. I ask unanimous consent to enter this into the record. Without objection, so ordered. Thank you. High-performing employees, people who are optimistic about their country, passionate about their work, concerned about their environment, trying to do a patriotic job, earn a living, and support their family. It is so discouraging when they see management rewarded for bad behavior and ignoring clear signs of misconduct. Like I said, this is not common. It's not regular. But when it does happen, every red flashing light in the building better go off at every level in Washington, D.C., in Chicago, and other places. And there can never be the retaliation like we are about to hear today. Again, I want to be careful about the treatment of this young woman. Please refrain from using her name. But I look forward to having this hearing here today, and now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. I associate myself with your words. And I must say, Mr. Chairman, as a husband and as the father of 2 beautiful daughters, as a brother with 3 sisters, and with a son, being a son of a beautiful mother, I want to thank you for holding this very important hearing today. First, I want to welcome the whistleblowers who are testifying on our first panel. They have some very troubling allegations. In short, they assert that an EPA official in Region 5 sexually harassed an intern and several other women, that managers in that region tried to cover up this activity, and that they were retaliated against after they tried to expose this wrongdoing. Those are some very, very strong and painful and unfair and unfortunate allegations. The three whistleblowers here today are the former heads of the Offices of Human Resources and Civil Rights in Region 5, as well as the Equal Employment Opportunity Manager there, holding very responsible and significant positions. I want to thank each of them. I know how hard it is to come forward in this public forum and to testify before the United States Congress and put yourselves out there, not only to this committee, but I'm sure to a C-SPAN audience. Our committee respects whistleblowers, and I say that without hesitation. And I can tell you that on both sides of the aisle, we have done everything we know how to protect whistleblowers. And we will continue to do everything in our power to ensure that all valid claims are thoroughly investigated and remedied. Let me also welcome Ms. Kellen. She represents the employees' union, and their core goal is to protect the rights and interests of hardworking and dedicated employees across the federal government. We welcome you, Ms. Kellen, and I've been a strong advocate whenever federal employees have been talked about in a negative way. I've been one who have constantly reminded all of us up here that we are also federal employees. Finally, I welcome Administrator McCarthy, who will testify on our next panel. Although the activities at issue today happened before she became the EPA administrator, we're happy Ms. McCarthy is going to be here, and we thank her for her service. Sexual harassment is intolerable and has no place in the federal workplace. Let me be clear on that. Sexual harassment is intolerable and has no place in the federal workplace. That statement may seem obvious, but it's still worth saying. In this case, there seems to be an agreement that on March 2nd, 2011, a little more than 4 years ago, an intern reported that an environmental scientist in Region 5 had sexually harassed her in that office. Based on the limited information we have, it appears that managers acted quickly in response to this incident. The branch chief notified his supervisor, sought guidance from human resource officials, and informed them about a prior incident about 7 years earlier. In turn, the human resource officials provided guidance, gave him a draft letter of reprimand, and urged him to move quickly. They met with the individual, who admitted that he, and I quote, crossed the line, end of quote. They issued a notice of proposed removal, and he left the agency in June of that year. Unfortunately, that was not the end of the story. Our witnesses here today also allege that officials in Region 5 retaliated against them for investigating this matter. Allegations of whistleblower retaliation are very serious, and they deserve to be fully investigated and substantiated if they are true. But that has not happened yet. Essentially, so far, we have only one side of the story. Our committee has not interviewed many of the people involved in this case. We have not requested relevant documents from the agency, and the Inspector General has not investigated these allegations. Mr. Chairman, in order to respect the rights of all federal employees, I recommend that this committee either initiate an investigation and a thorough investigation of these retaliation allegations, or that we ask the Inspector General to do so, and I will join you today in making that request. These whistleblowers deserve their claims to be taken seriously and to be investigated thoroughly. Finally, I believe that Congress needs to enhance the laws against discrimination and abuse rather than watering them down. Let me say that again. Congress, we folks up here, needs to enhance laws against discrimination and abuse rather than watering them down. For example, right now, current law does not prohibit sexual harassment or discrimination against unpaid interns or others who are not paid directly by an agency. Something's wrong with that picture. These are young people who come here trying to walk into their destiny, trying to get experience, working for free, sometimes from 9 to 5, 9 to 10, simply trying to be all that God meant for them to be. It appears that some of the victims in this case may have fallen into this category. In order to close this loophole, yesterday I introduced H.R. 3231, the Federal Intern Protection Act. This legislation is one that our entire committee should be able to support. And I hope that all of my colleagues will join in co-sponsoring the bill. In addition, the House of Representatives recently took up my bill, H.R. 1557, the Federal Employees Anti-Discrimination Act, which I introduced earlier this year. The House passed this legislation by a resounding, bipartisan, unanimous vote of 403 to 0. And I want to thank the chairman for joining me in co-sponsoring that bill and supporting it. I hope we can work together again to press the Senate to act quickly on that bill. What we should not do, however, is strip away existing federal civil service protections, as some of my colleagues have proposed. That is going in the wrong direction, and I respect many of our witnesses today. I would suspect that they would strongly agree with me. Again, Mr. Chairman, I want to thank you, and on behalf of all of those people who come to work for our federal government, who simply want to be the best that they can be, who simply want to be about the business of giving their blood, sweat, and tears to the public and making the public a better, place them in a better position, we say to you and to our whistleblowers, we will do every single thing in our power to protect you. And I say that, I'm sure, for this entire committee. And with that, Mr. Chairman, I yield back.
I thank the gentleman. I'll hold the record open for 5 legislative days for any member who would like to submit any written statement. We'd now like to recognize our first panel of witnesses. And I want to say at the onset, we do appreciate these people being here. This is not common to come testify in front of Congress, as we have many people that are come on a regular basis. These are people that are serving on the front lines and doing the good work for this country, and we thank them for being here. We are pleased to be joined by Ronald Harris. Works at the U.S. Environmental Protection Agency. He served at the EPA for 26 years in such positions as Property Supply Specialist, Grant Specialist, Labor Relations Specialist, and EEO Manager. Mr. Harris was reassigned to an unclassified duties at the Employees Services Branch in the Health and Safety Office. And we look forward to hearing his comments. We appreciate, as I read your bio, your participation in service in the United States military. We thank you for that service as well. We have Carolyn Boland. Did I pronounce that properly? Dr. Carolyn Boland is a distinguished manager and supervisor with more than 30 national and regional awards over her 28-year career at the EPA. Her awards range from Outstanding Achievement in Equal Employment Opportunity, presented by Susan Hedman, to the Federal Manager of the Year Award. She has quite a distinguished career, and we're honored that she's here with us today. Mr. Ross Tuttle is also with us here. He began his career in the EPA in 2009 as a Human Capital Officer, a Senior Manager position for Region 5. He currently works in Region 6 as a Senior Supervisor to the Regional Administrator. We also, as I read your bio, I thank you for your service in the United States military as well. Karen Kellen is joining us. She currently serves as the President of the American Federation of Government Employees and as an enforcement attorney for the EPA, and we thank you again for being here with us today. Pursuant to committee rules, all witnesses are to be sworn before they testify, so if you would please rise and raise your right hand. Thank you. Do you solemnly swear or affirm that the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? Thank you. You may be seated. Let the record reflect that all witnesses answered in the affirmative. In order to allow time for discussion and the fact that panel 2 will include the EPA Administrator, we would appreciate it if you would limit your verbal comments to 5 minutes. Your entire written statement will be entered into the record, and as we go through the hearing today, if there are additional comments, information that you would like to provide to the committee, we would obviously welcome that on a timely basis. But if you could please limit your comments to 5 minutes, we will start with Mr. Harris and go down the line, and then after that we will go to the questions section. Mr. Harris, you are now recognized for 5 minutes.
Good morning, Chairman Chaffetz, Ranking Member Cummings, and other distinguished members of the committee. My name is Ronald Harris. I am an EEO employee and specifically an EEO specialist located in the Region 5 Chicago, Illinois office. Thank you for inviting me to submit a statement for the record with regard to sexual harassment, discrimination, and retaliation that took place in the Region 5 Chicago office by several EPA managers, the highest level managers within various divisions in the region. I also would like to thank my attorney, Mr. Wade Stuhl, for his tireless efforts in representing me with regards to the issues I endured in this 4-year battle with the agency. I watched the EPA hearings titled EPA Mismanagement, streamed on April 30 of 2015 before this same committee, and was literally sickened to see the stories depicted were so similar to mine with regard to the following: sexual harassment, the length of the harassment, and the regional cover-up about these blatant and willful discriminatory activities by management officials. After viewing the hearing, I was more determined than ever to share my experiences as it related to the similar scenario within the EPA. Ironically, I am here before you again as I offer testimony before the 106th Congressional Committee nearly 15 years ago. The issues that were prevalent then are similar issues that I appear before you today to discuss. During the opening statement of the 106th Congress by Chairman Sensenbrenner, he stated, "Retaliating against those who speak out against the agency is not acceptable. Failing to enforce EPA disciplinary policies against those who are found to discriminate or harass is not acceptable. All of these actions send a message to EPA employees not to speak out, not to engage in public debate, and not to dissent against the agency." He further stated, "The EPA managers or officials that have been found to discriminate, harass, and intimidate other EPA employees or the public should be disciplined." This does not appear to happen. I chose to highlight Chairman Sensenbrenner's prior quotes to use in this opening statement today because very little has changed within the EPA management culture Region 5 office, despite the fact that these statements were made a decade and a half ago. This lack of change has a direct correlation to the absence of accountability. To expect change without accountability is wishful thinking at its best. The regional office has chosen to offer the reward for going along to get along over accountability. In Region 5, this type of managerial mentality strengthened resistance and animosity toward change because the sentiments spoken by Chairman Sensenbrenner and the 106th Congressional were viewed as oppositional. To further illustrate this point, the over 500 documented pieces of evidence I provided to this committee reveal that when I and Dr. Boland followed agency protocol and reported allegations of sexual harassment activity toward female interns to the EPA Washington headquarters office, we discovered through our investigation as EEO officers had been going on for at least a decade and involved more than a dozen women, and we were immediately retaliated against by Mr. Bharat Mathur, Assistant Regional Director, and removed from our positions in the Office of Civil Rights for following agency protocol and contacting headquarters. Despite the fact that Mr. Mathur had a legal obligation to prevent discriminatory activity within Region 5, he was rewarded with a $35,900 award approved by Washington headquarters to further supplement his $179,000 annual salary. This award was given to Mr. Mather, was approved by the Region 5 Administrator, Susan Hetman, and management officials within the EPA Washington headquarters as well had to make this approval. Other Region 5 senior managers who were also named participants in these discriminatory cover-ups and retaliatory activities also received awards approved by both Regional Administrator Hedman and Assistant Regional Administrator Mather. These monetary awards should have to be repaid to the government so that the earlier statements made by Chairman Sensenbrenner and further echoed by this honorable committee today will send a strong message that discrimination and retaliation does not pay and there must be accountability. Another claim that I mentioned in 2000 to the 106th Congressional Committee was that Region 5 and EPA lacked an agency process for dealing with managers who retaliated and discriminated against regional employees. 3 years later, in 2003, in a USGAO report to Congress entitled Environmental Protection Agency, Continued Improvement Needed in Assessing Equal Employment Opportunity, on page 15 stated that the EPA had no formal process to discipline managers found for discrimination. Further, on page 16 of this same report, the GAO concluded, accountability is the cornerstone of results-oriented management because EPA's management sets the conditions and terms of work. They must be accountable for providing fair and equitable workplaces free of discrimination and reprisal. By implementing the 2003 USGAO report, this honorable committee can send another strong message that the word accountability applies to these management officials too.
Thank you. We will put your entire written record into the or your entire statement into the record. So
Thank you, Chairman Chaffetz.
We have questions, so we want to get to your questions. So yeah, thank you.
Thank you.
Dr. Boland, you're now recognized for 5 minutes.
Good morning. Thank you. Good morning, Committee Chairman Chaffetz, Ranking Minority Member Cummings, and esteemed Congressional Committee members. I appreciate the invitation to speak before this illustrious committee this morning to discuss my experiences with regard to the violations of the Title VII Civil Rights Act of 1964 and Section 501 of the Rehabilitation Act of 1973. Unfortunately, I was subjected to these violations at the behest of the EPA Region 5 Administrator, Ms. Susan Hedman, and her former Deputy Administrator, Mr. Bharat Mather, the two highest level managers in the region. In God I trust that my testimony today, along with that of my colleagues present here this morning, will not result in further retaliation. We have the courage to speak before you, acknowledging that we have undergone 4 years of turmoil and consternation as a result of performing the requirements of our jobs. The actions waged against us were indeed an infringement of our civil rights and an embarrassment to the agency at large. I want to acknowledge and thank Mr. Wade Stuhl, my legal counsel, who is here with us today. My testimony is not intended to diminish or tarnish the meaningful work that many Region 5 employees, supervisors, and managers engage in on a daily basis to ensure that the air that we breathe, the water that we drink, and the land in which we live is safe for us all. I have devoted my career and efforts as a manager to the mission of the EPA. I will note that I am the recipient of the Regional Administrators Award for Excellence, which was presented by Susan Hedman in June 2010 for outstanding achievement in EEO through redesigning the Region 5 mentoring program. I also received the National Prestigious Manager of the Year Award from the Federal Managers Association in 2010 as well. Nevertheless, I will speak about the office bullying, mismanagement, and retaliation that I was subjected to while serving to direct the Office of Civil Rights from September 12, 2010 to July 31, 2011. My life and professional career was disrupted to the point that I had to file a formal discrimination complaint against the agency in September 2011. The complaint was based upon the overt discrimination practices that were perpetrated against me and my staff during that period. On August 23, 2010, I was selected by Ms. Hedman and Mr. Mather to provide my leadership and assistance in restructuring and redirecting Region 5's OCR. As my personnel records indicated, I was reassigned as the Director of the Office of Civil Rights. Mr. Mather had been the second-line supervisor for the OCR for several years. The office had been grossly mismanaged, and Mr. Mather asked that I clean it up. He asked me what it would take for me to consider the job. I remarked that it would take a GS-15 for me to undertake the challenge. I explained to Mr. Mather that I was a person with a disabling condition and with documented reasonable accommodations. Both Mr. Mather and Ms. Hedman were eager for me to start the job, and they thanked me for accepting it. Although my effective date was September 2010, I began working in August of 2010. I worked 2 jobs simultaneously. Mr. Ronald Harris was the EEO officer and the highest performing employee in the OCR. We worked long, arduous hours developing overdue reports, preparing strategic 2- and 3-year plans, and I rewrote existing manuals, prepared special emphasis events while reorganizing and restructuring each group. The work was grueling. The office was understaffed and lacking resources. I repeatedly informed Mr. Mather of the staff shortages. Mr. Mather continued to give me assignments. Some were not related to OCR, like being made to prepare speeches for him and Susan Hedman, which was very odd, especially since they had 2 speechwriters dedicated to them. The work was unrelenting, and with computer work and extensive writing, I made Mr. Mather aware that I had began to experience serious pains in my neck, shoulders, and back. In January 2011, Ms. Cynthia Colquitt, a former employee of OCR, came to us on a detail. She did an excellent job. Ms. Colquitt went on to receive the Region 5 Administrator's Professional Award. They staged the show to support OCR, but did not take the time to discuss the 2010 Regional Workforce Status and Analysis Report, which illustrated the participation rate of general scheduled grades by race, ethnicity, and sex. It showed the full and part-time trends, which demonstrated and impacted the racial makeup of the region as compared to EPA nationally and compared to the national civilian labor force. Mr. Mather and Ms. Hedman canceled those meetings with the EEO office on 3 different occasions. When Mr. Mather was asked why we are postponing the meetings, he laughingly responded to Mr. Harris and I and said, "This meeting is canceled indefinitely," and he walked away from us and closed the door. It was apparent that these managers who set the tone for the region failed to embrace diversity and the principles of EEO in their leadership roles. The chances of addressing upward mobility initiatives and advancement of qualified minorities to higher graded positions was a moot point with them.
Dr.
Okay.
Thank you. We have to, we have your full written statement.
Okay.
And we want to get to the questions.
Okay.
And we're going to run
Thank
short on that, so we're going to elect to err on the side of having more time for questions. And Mr. Tuttle, you're now recognized for 5 minutes. And remember, you can summarize this. We've got the full written statement, but Mr. Tuttle is now recognized for 5 minutes.
Thank you. Good morning.
That microphone a little bit, straighten it out and move it right up there. There you go. Thanks.
Good morning, Chairman Chaffetz, Ranking Member Cummings, distinguished members of the committee. I thank you for this opportunity to come and address you today. My name is Ross Tuttle. Since January of 2014, I've been employed as Senior Advisor to the Assistant Regional Administrator in EPA Region 6, Dallas, Texas. Prior to this reassignment, from September of 2009 to January of 2014, I was employed as the Human Capital Officer at EPA Region 5 in Chicago. I appreciate this opportunity to testify in front of you today, and I do so with a significant amount of trepidation, despite my belief that it's the right and proper thing to do. I can concur in what my colleagues have said with regard to the sexual harassment that took place of the interns. I investigated that case as well from the administrative side and human resources, and found in my investigation that that went back with that perpetrator, and I stopped my investigation and stopped taking statements at the year 2000, and this was in 2011 that this was brought to my attention. So I can concur in that. When I got stonewalled after the perpetrator was allowed to retire, and I decided I was going to pursue action against members of management that had concealed this for so many years. To use a phrase, EPA management circled the wagons and stonewalled me, and I was not able to pursue that at all. And I believe firmly that that did a significant amount of damage to my reputation in Region 5. There were other incidents that I had to deal with in Region 5 that are included in my statement that I shared with the committee on other actions where I was not well received and was in fact treated with less than a cordial amount of professional respect for what I was doing. And that led me in April of 2013 to file a complaint against my division director at the time, Cheryl Newton, who was the assistant regional administrator in Region 5 in Chicago. That was settled, but then I was reassigned to Region 6 in Dallas, Texas, and the retaliation continued in Region 6 in Dallas. My position as the senior advisor to the assistant regional administrator should be one of significance in that I'm providing guidance and advice to the ARA in his job. From a human capital standpoint, I am responsible for providing him advice on differing issues that are important to him so that he knows what actions to pursue. In actuality, in the time that I've been in Dallas, I've had only 2 assignments that would be considered respectful of my expertise and my grade. One of those was to coordinate the early out buyout program for Region 6 that was initiated in November of 2013. Based on the way that should work, that would have been a significant project. In actuality, the only thing I ended up doing there was coordinating applications, a list of applications that came in from people that were eligible, and I did the final wrap-up report that's provided to the Office of Personnel Management. The other assignment that should have been significant as a follow-on to the early out buyout was a reorganization and restructuring of Region 6. And again, the way that should have worked, that would have been a significant undertaking. I was assigned initially to chair a regional reorganization work group that was supposed to evaluate options and bring recommendations to senior management. In actuality, the only thing I did there was sit on a work group as a panel member along with 2 of my colleagues from Human Resources who were not allowed to participate in those meetings. Management did what they wanted to do with those. And I ultimately ended up only looking over packages, the packages that were put together to submit to our headquarters. I just looked them over to make sure that the right forms were there and the signatures were there. Since that's been completed in early April of this year, I've had no meaningful assignments at all. And as in my statement, I've told you how my ARA approached my mid-year evaluation and what my plans are, because I've signed a modification agreement that to protect myself and not have me go back to Region 5 to that environment I was in, that now essentially compels me to retire in December of this year, an action that was unpalatable then as now. Thank you for the opportunity.
Thank you. Ms. Kellen, you're now recognized for 5 minutes.
Chairman Chaffetz, Ranking Member Cummings, thank you for inviting me to testify today. I've worked at the EPA for 28 years, the last 2 as the president of AFGE Council 238. Council 238 is the largest union at the EPA. We represent about 8,500 employees. EPA is an agency of proud and dedicated civil servants with a strong work ethic. However, bad management practices have become routine, causing everyday duties to become stressful and difficult. This hinders the agency's ability to function effectively and efficiently. There's a double standard in which the rank-and-file employees accused of lesser offenses are often treated harshly, while managers who bully and harass their employees are rewarded with promotions and large bonuses. Allow me to present some examples. First, I'll speak to the aftermath of the testimony before this body on the misconduct of Peter Uttrell, who was accused of sexually harassing multiple female EPA employees. After that testimony, EPA held an all-hands meeting with his staff to discuss the testimony. Staff were encouraged to speak freely, but as information was shared, it became clear that EPA senior management did not want to hear about the extent of the harassment. They attempted to limit the input by stating that Peter was not here to defend himself. Management chose to defend the indefensible rather than addressing the serious allegations of misconduct. Another incident involves a former employee who had a stellar work record and an international reputation in the scientific community. Upon her division director's retirement, her new manager was appointed using Title 42 authority. Title 42 positions are intended for short-term consultants with specific expertise. EPA has been using this authority to hire managers. Soon after his arrival, the new manager began to harass and bully the employee. He canceled previously approved speaking engagements at scientific conferences, even though it was part of her job and there was no cost to the agency, while allowing the men in the office to continue to pursue these endeavors. After months of this behavior, she filed an EEO gender claim. The manager was not deterred, but was emboldened to try to find a way to have her removed from federal service. EPA searched her desk and her email in an effort to manufacture ethical violations relating to conference travel and planning activities. EPA then fabricated charges and proposed to remove her from service. Despite the lack of any threat on her behalf, they escorted her out of the building with a specially hired armed guard. The employee was forced to hire an attorney to defend herself. The agency ultimately reduced the termination to a 2-month suspension. When she returned to the office, the harassment intensified. This employee ultimately found new employment as a full professor with an endowed, tenured seat at a major U.S. university. Her EEO case went to trial in June of this year. After a 5-day trial, the 12-person jury took less than 2 hours to return a verdict in her favor. They found that the agency had retaliated against her and awarded her back pay and substantial compensatory damages. It's not easy to fight the full force of the federal government. This woman had to refinance her home and tap into her retirement account to pay for the legal costs. While she prevailed in court, EPA lost a valuable employee. And those responsible for this reprehensible behavior have never been held accountable. These are not isolated instances, just specific accounts of systematic breakdown. The agency has too many managers at senior levels who regularly bully and harass employees. Today, I ask Administrator McCarthy to stand with the good, hard-working employees of the EPA and work with the unions to address the harassment, bullying, and retaliatory behaviors within EPA. Finally, I ask the members of this committee to distinguish between the very public problems that you're hearing about and the vast majority of EPA employees, both staff and managers, who want nothing more than do a good job for the American people. When the rhetoric about federal workers as lazy, unproductive, or unresponsive to the public is tossed about without consideration to the men and women who labor for the government, it demeans and demoralizes employees. Please do not paint all federal workers with the brush of a few problem employees. Federal employees deserve the respect of the nation, not its scorn. They are what keeps this country working day in and day out. Thank you.
Thank you. I now recognize myself for 5 minutes. What I would like to do is talk specifically about the case with intern X, as we're referring to her. Please, I admonish members, the people on the panel today, do not use this person's name. Paul Bertram was accused of harassing several women over the course of time, and specifically, I want you to give me your firsthand account of what she went through. What do you know specifically about this case involving Paul Bertram? What was his history, and what happened specifically to this intern? What was your findings, your personal involvement in that? And we'll start with Mr. Harris.
My personal involvement is that I was contacted, I believe, right around sometime in March. She had spoken with another young lady, Ms. Deborah Lamberty, whose statement you wrote, and told her, get in touch with me, because she didn't feel like anything was happening. When she got in touch with me, I made several appointments to see her, took her the necessary documents. We discussed what was to take place, what had taken place. I recorded everything. I then contacted my director, Carolyn Boland, and then we proceeded from there. Emotionally, mentally, intern X was a wreck. It bothered her. She was strong. She did prevail. She kept saying to me, I just wanted to stop. How do I get it to stop? She contacted an individual who was the lead person, who was supposed to have been addressing the issue, and she did not hear back from them for 3 weeks. And during this 3-week period, other incidents still occurred. She also continued to let the supervisor know, who also took no action. At that point, my advice to her, you might have to file something in order to get them to do the right thing.
And what happened? What ultimately happened?
I spoke with her about what it would take to file something. She said she could not. She just simply couldn't afford it. Her and her husband, I believe that's her husband at that time, were just getting their lives together. They both were in graduate school. They just did not have the money to pursue anything.
Why couldn't you do anything internally in the office? I mean, you make a complaint.
She did an informal complaint.
But what happened? They just moved the cubicle? That's all they did?
Yeah. And then they moved her cubicle first. When we got involved in the OCR office, we then said, wait a minute, that's not the way you do this. You moved the aggressor, not
When you say move the cubicle, like how far?
Originally, they moved, I believe it was 4 cubicles down.
So that was going to solve the problem, move it 4 cubicles down?
Yes, and we insisted, no, move him to another floor.
Dr. Boland, what was Paul Bertram doing to this intern?
To my knowledge, he was touching, groping her, kissing her, and she was feeling very uncomfortable by his advances. She had asked him to stop, and he continued to do it. And Mr. Bertram's, or Dr. Bertram's, advances were well known by management, and they had just been going on for years. Excuse me. The intern, along with two other ladies came to my office along with Mr. Harris to report the situation. They were very upset, all of them. What they finally did was to give a number of testimonies to us. Mr. Harris and I prepared a 12-page summary document and prepared it for the Human Capital Officer, the Office of Regional Counsel, as well as Mr. Mather. And we gave the allegations, the persons who were involved, the comments that were given, and we gave recommendations.
And what happened?
Mr. Mather was irate with Mr. Harris and myself for writing up the 12-page summary. He questioned us and shouted and yelled at us, intimidated us, and said, "Why did you report this to headquarters?" Mr. Harris stated to him that it is the procedure to report sexual harassment and discrimination claims to headquarters. Mr. Mather banged on his desk, pointed his finger, and said he was not interested in hearing that EEO, and he used an expletive when he referred to it.
What's Mr. Mather doing now?
He has retired. He retired. And
What happened to Paul Bertram?
Paul Bertram, to my understanding, retired, but he was seen in the building several times for several months after that at meetings, at various meetings, so I can't tell you exactly why he was there, but it looks suspicious.
Mr. Chaffetz, may I make a comment of
Yes.
what Dr. Boland said? The agency, especially the direct level supervisor, Mr. Paul Horvaton, they were going to issue a reprimand again to the same guy, despite the fact they had known all these years and had all these accusations against him. Once we stepped in and met with Mr. Mather, myself and Dr. Boland, said, "You can't do this. You've got to do the right thing and elevate this to more than a reprimand." Only then did they move to remove him.
How many previous reprimands had Dr. Bertram had?
According to the witness statements that I remember and observed, there were 3 to 4.
Thank you. Yield to, now recognize the ranking member, Mr. Cummings.
Thank you very much, Mr. Chairman. As I've listened to this testimony, it is indeed very alarming. But having practiced discrimination law when I first came out of law school back in 1976, it does not surprise me. To all of you, to Mr. Harris, Ms. Bowler, Ms. Tuttle, first of all, I want to thank you for standing up for what you believe to be right. My favorite theologian says that it is what you do when you're unseen, unnoticed, unappreciated, and unapplauded that matters the most. And I'm sure that you all have stood up in many instances where you were not applauded. As a matter of fact, you got slapped for doing the right thing. Mr. Tuttle, the idea that you have been basically forced out of federal government, I mean, is that a fair statement?
Yes, that's essentially correct. I was handed it as part of what could have been and should have been a routine reassignment to Region 6. I was handed a modification to my original EEO settlement agreement that stated in part, and as I said in the record, stated in part in exchange basically for being permanently reassigned to Region 6, I agree to voluntarily retire no later than December 31st of 2015, and that EPA is authorized to initiate the documentation to indicate that.
But let me say this, that, as I listened to the testimony, one of the things that is being said that is not being said is that when you all are being retaliated against, that means that you cannot do the job that we're paying you to do. Come on now.
That's correct.
You can't do the job that we're paying you to do.
Correct.
Your effectiveness and efficiency is diminished.
Correct.
And so that's a double whammy. Not only do you suffer, but the taxpayers can't get what we're paying for. And so that's why I'm so appreciative of what you have tried to do. And one of the things that is just bearing into the DNA of every cell of my brain is the idea, Mr. Harris, that back in 2000, you were making the same types of statements, I guess,
That's correct.
in 2000, which means that over the course of 15 years, over and over and over again, obviously there have been folk who have been damaging people, harming them, and then moving on or doing or being promoted. Is that right? Is that a fair statement?
Yes.
Now back to you, Ms. Kellen. I think that we need to be, I'm glad you said what you said the way you said it. That we have a way up here of maligning federal employees over and over and over again. But the fact is that we have some folk who are not doing the right thing. But you said something that's very powerful. You said the management gets rewarded. Am I right?
Correct.
But on the other hand, the rank and file, the folk getting up at 6 o'clock in the morning, giving their blood, their sweat, and their tears, they get messed over. Yeah. Am I right?
Absolutely.
We're better than that. Yeah. We are. Now, Dr. Harris, Mr. Bowler, Mr. Tuttle, you know, I'm very concerned about the allegations you raised, especially your claims that you were retaliated against for investigating this activity. Now, I understand that we have not investigated your claims yet. We haven't talked to your managers to get their responses, and we haven't requested any documents that would shed light on your claims. I hope we will do that soon. As I said to the chairman, you know, I think we need to have the IG to look in this because this stuff is culture. Yeah. I mean, you got to dig deep. In Baltimore, we had a situation where we had some concerns about our police department, and I asked for a patterns or practice examination. You know why? Because I knew that in order to deal with the culture, we had to dig deep. Yeah. I mean, you cannot just leave this on the surface because what'll happen, Mr. Harris, is that you'll be here, God willing, 15 years from now, making the same allegations with more victims having fallen by the wayside.
Yeah, that's correct.
What a waste of taxpayer dollars, but more importantly, what harm comes to people who are simply trying to walk into their destiny. Yeah. And it's sad. We're better than that. And I thank you for what you're doing. But let me go on just one more minute. I want to ask you about the recommendations you made in your testimony and some legislative proposals that Congress has considered. Mr. Harris, you urged the committee to require EPA to develop a process to hold managers accountable for discrimination and retaliation. Is that right?
Yes, I did.
I have a bill called the Federal Employee Anti-Discrimination Act that just does just that. It says, and I quote, accountability in the enforcement of federal employee rights is furthered when federal agencies take appropriate disciplinary action against federal employees who have been found to have committed discriminatory or retaliatory acts. Mr. Tuttle, do you agree with that statement?
I absolutely do.
And further, my bill would require agencies to track every single complaint alleging discrimination from inception through resolution, which is not required now under federal law. My bill would also require agencies to notify the EEOC when violations occur, and it would require agencies to report on their websites whether a finding of discrimination or retaliation was made. Dr. Bowler, I realize these steps are not a silver bullet, but do you think they could help bring some additional level of accountability to the process?
I do. I do think that this is exactly what's needed.
Well, I've run out of time, but let me say this. You know, I've seen so many people over the years, over my being in practice of law, I mean, people who have gone through difficulties and then they were looked upon like you, Mr. Tuttle. They tried to do the right thing, and then they filed suit or whatever, and while waiting for the suit, they died.
Yes.
Yeah.
They died.
Yeah.
Yes.
I've seen that over and over and over again, and I'm so glad that you all are coming before us. Hopefully we can get to the bottom of this so that 15 years from now, we won't be going through the same thing, Mr. Harris. Thank you, Mr. Chairman.
Congressman Cummings, may I make one comment on the bill that you're going to introduce?
Please.
We need to include the language in settlements because as your bill might indicate, those who were found guilty. But when issues are settled, there's a clause.
Yeah, there's a non-disclosure clause, and we addressed that in the bill also. By the way, I didn't get a chance to ask you about that. Because what happens, you're right, when they settle, they put a non-disclosure clause in there, and so therefore, the very acts that brought about the settlement, they can't talk about them. Right. So therefore, they go going on and on and on. Thank you, Mr. Chairman.
Thank you,
The
Congressman.
gentleman from Maryland yields back. The chair will now recognize the gentleman from Michigan, Mr. Walberg.
Thank you, Mr. Chairman. Ms. Kellen, thank you for being here from your position as president of the Council 238. Could you just summarize the basics, the general approach as to how EPA leadership handle cases of misconduct or harassment by management?
Frankly, it varies from location to location. We do have some locations in which management has been responsive in listening to us and starting to address the problems, although I have to admit that the solutions that they come up with tend to be feckless, frankly.
What does the responsiveness look like, just briefly?
Responsiveness looks like an acknowledgement that the bullying behavior is happening and that there is a problem. The response, however, is to send the bully who's been doing this for 20 years off for training for 3 weeks with master's credit. I actually asked if I could be sent off for 3 weeks of training with master's credits. In other instances, there is complete denial of what's going on. Frequently what happens is when you raise the issue with one level of management, they join forces. Managers stand together as one, and the manager is always right. The manager is the one who is telling the truth, and the employee is the problem.
Does that promote in the culture of EPA, an effective, productive workplace?
Oh, no. It undermines the work people are trying to do. These people just want to do their job. And if we just get out of their way, they would give great service to the American public. But instead, you get this whole culture of everything starts to revolve around the problems, and it just undermines everything we do.
In your testimony, Ms. Kellen, you say that the managers are not held to the same standard as their employees. Elaborate on that a little bit more. Explain it to us.
Okay, so what we see after the John Beale situation, which I'm sure you're all aware of, was the CIA impersonator.
Right.
The agency came down very hard on employees on time and attendance issues, to the extent where there are times when single mothers are gotten in trouble for being 5 minutes late once in a while. We had an employee who was severely ill, who was forgot to request his leave to take his doctor's appointment, 1 out of like 40 visits. Despite the fact that he was working again later in the afternoon, he was put on AWOL for that period of time because he didn't ask ahead of time. Yet the managers pretty much walk free. They do as they like, and they're not held accountable.
I guess this is a crucial question for me to hear from you, because you've talked with your membership, other employees. What steps do you think leadership at EPA should be taking to address these management problems?
Well, I think the first place to start would be developing a feedback loop. One of the issues I see is that when you have a bullying situation going on, the bullies tend to be very good at managing upwards. So the senior leaders never see that behavior. And they need to listen to the staff. They need to listen to the employees. And when you're managing, you learn that there are some gripers. But when the problem expands beyond those few people who are always griping to a larger group of people, you have to listen to the employees. So we need to develop a feedback loop to make sure that senior leadership gets feedback about how managers are doing within this process.
And ultimately, they listen to it.
Well, that's the next step, that they actually have to act upon what they hear.
Okay. Mr. Chair, I yield back.
The gentleman from Michigan yields back. The chair will now recognize the gentlelady from New Jersey, Ms. Watson-Coleman.
Thank you, Mr. Chairman, and thank you very much to the panel for being here and sharing this very painful information. I spent much of my career working in EEO affirmative action, and so I understand the sort of frustration that when the system just doesn't do what it's supposed to do. And I'm not quite sure I completely understand your system, but I think we're dealing with two issues here. We're dealing with what does this agency do when it has a discrimination complaint? What is the process? What do you do? Like the sexual harassment complaint. And then the other process is what happens to individuals who try to stand up and make the system work right, the whistleblowing. So let me go to the first piece. The first piece involves a sexual harassment, a discrimination complaint that you all investigated. This is a very toxic environment that you've described as it relates to sexual harassment with regard to this one individual. But is there a culture there that there's discrimination because of race and gender assignments also? Yes. Is this, and I don't know who can best answer that, Dr. Boland?
Yes, there is definitely the culture.
So have you all been called upon in that region to investigate discrimination complaints based on race, creed, color, all that other stuff?
Yes, we have.
And do you have the same reaction or response from the higher-ups with regard to those cases as you did with this case involving sexual harassment and this doctor?
Actually, I think that the higher-ups are not concerned with those types of cases. And by the way, I might add that I was removed from the Office of Civil Rights as a result of my doing my job. Mr. Harris and I worked diligently with employees and with managers to make sure that they understood the policies of EEO and affirmative action. And I think that the attitude comes from the top.
So
and if,
when you say the top, are you referring to the top of your regional office, or are you talking about headquarters?
well, it's the top of our regional office, and of course, that should come from headquarters.
Okay.
I think it's a trickle-down effect.
So let me ask you a question. You investigate cases of discrimination, sexual harassment, whatever. You have a responsibility not only to report that to your regional office, but you have a responsibility to report it to headquarters also?
That is correct.
So you, and in doing so, you were then harassed, allegedly harassed on your regional level, right?
Yes, we were.
Is there a policy in place in the department as it relates to whistleblowing, harassment of whistleblowers?
Yes.
And what is that policy,
I'll defer to Mr. Harris.
Mr. Harris?
They have a policy, but it's more or less a statement. There is no official step 1, step 2, step 3, but they send out a policy statement every year. So if you're asking me, are there steps involved? No. And this is why one of my recommendations is there should be. I want to respond back, if I may, to another part of the question or remark that you just made. One of the biggest issues that I've seen in doing this over a 10, 15-year period, it is our own regional counsel's office. The moment discrimination complaints informally or even are mentioned, the attorneys dig in with the managers. This is not the way the OCR process is supposed to work.
Then let me ask you a question about that. Has the department established any kind of sort of training and accountability on a routine basis?
Yes, they have. Matter of fact, as I indicated in my statement, in 2004 and 2008, the same managers that withheld with doing anything with regards to the sexual harassment, they attended the training. I submitted that as part of the evidence. The attorney, again, who defended the agency during an informal process, documents were sent out by then Karen Higginbottom, who was the director, saying they should not be involved. Prior to that, 1998 stated they should not be involved.
Let me ask you a really quick question. Anybody can answer it. Is it better as a result of your being here today, as a result of the sort of prominence associated with the issue? Is the culture better? Is there more accountability? Are there any steps moving in the right direction being done by the administrative branch?
I can only speak on what I know, and right now, just recently, there was another issue. I brought it to the DRA's attention, who is new. and he addressed it right away.
Okay.
This is what's needed. Now, how long he'll be able to do that with that institutionalized culture, that's the question mark.
And if I could, as a lawyer, I'd have to say it depends. Because it's very dependent on the senior career leaders and in each location. And I have found that some locations, the political leadership is stepping in and really trying to make a difference.
So consistency or the lack thereof is a big issue here.
That is correct.
Okay.
Yes, absolutely.
Mr. Chairman, may I just ask one final short question?
Yes, ma'am.
And this is to Mr. Tuttle, because he explained that he had investigated cases against Dr. Bertram as
ma'am.
far back as 2000,
Yeah,
and then you stopped.
Yes.
Can you tell me why you stopped and what happened with the findings of your investigations? Thank you, Mr. Chairman.
Yes, ma'am.
Thank you for asking. I stopped at the year 2000 because I had, in my part of this investigation, I was doing it from the administrative side of the House as opposed to the civil rights side. And I'd gotten the names of previous interns who had been through the same thing, and I stopped at 2000 because that was the last point that any of the either the employees that I had talked with or the interns could give me any information or contact information on who to reach out to. And I'd like to add, for the benefit, one of the things that was among the most disturbing things that I saw in those statements, one intern specifically stated that because of what had happened to her and what had not been done, it not only changed her mind about a career with EPA, it turned her off from government service completely, and she ended up getting a job in a completely unrelated profession.
Gentlelady yields back. The chair will now recognize the gentleman from Wisconsin, Mr. Grothman.
Thank you. Thank you all for your testimony. For most of us, or at least for me, when I think of the Environmental Protection Agency, I think of, touring local farms, factories, that sort of thing. And what they feel are, first of all, rules that are lacking in common sense, causing huge cost of money, perhaps chasing jobs out of America. Now, you guys are not psychologists, but I'll ask you maybe to comment. I wonder, do you think the same apparent psychological problems with the management at EPA, the bullying, okay, the getting revenge on people, not dealing with legitimate questions but just walking away, is that psychological problem that you are experiencing, do you think those same psychological flaws in the EPA management is what is causing problems for American business or American landowners?
If I could respond. I believe that when you allow a bullying culture to exist with managers, that those employees who have those tendencies will also act that way towards the public. I also think that is more rare. I think you hear about the worst ones, but on the day-to-day operations, unfortunately, what I've seen is that some of our employees in the field have been harassed and threatened by the public because of the environment towards us. But I think if there are instances of that out there, that the bullying culture definitely lends itself to that.
Well, what I'm saying is I'm extending even to the people who write the regulations that American business, that American farms have to live under. Okay, now a normal human being in writing these regulations would have to realize that when you write them, it's going to be very costly, it's going to result in a lot of ambiguity in the regulations, it's going to create a situation in which individual employees can make subjective decisions that, quite frankly, ruin businesses and ruin people's lives. Do you feel, if this is the culture and the management of the EPA, that these personality flaws are perhaps one of the reasons why we have such onerous regulations coming out of the EPA?
If I may respond.
Yeah.
Yes, I do. You have a culture of arrogance beyond the shadow of a doubt that you could ever see. The arrogance. And when you have that level of arrogance and unaccountability, there's an untouchable feel about this individual now. So yes, I know it transfers over to the public.
And if I could as well address that, I think part of the problem with that is just, I grew up in a town of 400 people, so I know what it's like in rural America. And the rules you come up with in Washington, D.C. just don't always make sense when you get down on the farm. And I think that's a challenge in general. And I think one of the things I would caution you on is that currently the federal government itself is so loaded down with regulations that control us and tell us how we can and cannot do things that it's impossible to operate effectively or efficiently.
Do you think it's possible, and obviously, we're not going to get rid of the entire EPA, but do you think it's possible, given the huge culture of arrogance at the top, apparently covering so many employees, is it possible for the EPA to reform itself and work with American people rather than right now where it is perceived as, I mean, really a problem agency that seems like its sole goal is to harass people and come up with regulations that lack common sense? Are there enough good people less than the EPA that it could even reform itself? Sure, Mr. Harris.
I believe EPA can be reformed, but not without accountability. There's no way you're going to have change and reform without accountability. Until you initiate accountability, do not expect change.
Just one more question. Do you think it would be better, given the huge problems you have, to take at least some of the responsibilities the EPA has and give them back to the various Department of Natural Resources around the country?
They have working in the HR issues, they have what they call a delegation of authority. If EPA cannot perform in a satisfactory manner and eliminate that culture of arrogance, a delegation of authority should be in place to take that authority away and give it to somebody else. This is how you hold an agency accountable.
Thank you very much, Mr. Harris. We'll see if we can do that.
Thank you. Thank the gentleman. Now recognize the gentlewoman from Michigan, Ms. Lawrence, for 5 minutes.
Thank you. I just want everyone to know here today that sexual harassment in the workplace and allegations of management cover-up are something I take very seriously. As a matter of fact, during my tenure with the federal government, I served as an EEO investigator. So these are things that the process and the sensitivity to this I take very seriously. So one of the protections in place throughout our executive branch is the Office of the Inspectors General. And this committee has worked to strengthen the role of the IG because of the critical importance of an independent investigation when allegations such as this arise. So my question to you today, to the members of this board, Mr. Harris, did you contact the IG or did you consider doing so?
No, we did not contact the OIG. My reasons for not contacting, or the individual contacting them, in Region 5, OIG is seen as an extension of management, and many employees are intimidated to contact them. The reason for this, because when certain managers with the bullying tactics, the first thing they do, they contact OIG and sick them on the employees. So the persona of the OIG regional office is not the persona that it should be, because they're used as extensions of management to attack employees. So no one wants to talk with them.
So would you say, for the record, that you feel that the IG, as we call them, actually are part of the conspiracy of what happened in this case?
No, I do not. I think OIG themselves independently will and can do a good job, but the perception of the employees toward OIG, and no, I do not think there's a conspiracy. I think OIG would investigate the facts as they are, but the perception.
But they were not given the opportunity.
That is correct.
And I might add that there is a certain clique of managers that seem to follow the same pattern. It is not all supervisors and managers that have this opinion or that operate in this manner. But there is a certain faction within EPA that seems to have the attitude that Mr. Harris just, the arrogance and the entitlement and that idea of being above the law. And those are the managers that taint the region, that cause low employee morale. And those are the ones that need to be isolated and dealt with and held accountable.
Mr. Tuttle, could you respond to that question pertaining to the IG?
Well, I was going to ask us to weigh in on this. I knew personally two people that worked in the office of the IG in Region 5 that were investigators. I'd met them independently when they came down to my office to seek information about other issues. And while I was completely comfortable that if it was left to them that it would be investigated, I too was not, I'm like Mr. Harris, I was of the impression that the IG's office has the persona of being an extension of management. Contacting the IG would have normally been one of the things I would have recommended, but I wasn't comfortable doing that.
Ms. Kellen?
Yes, just to let you know, I have reached out to the IG, and unfortunately, our meeting was canceled last week because of various reasons. But my intention is to work with the IG to try to find a way to address these issues and to try to reopen those lines of communication so that employees do feel comfortable reporting that. So that's an ongoing effort that we are making right now.
Well, again, I want to reiterate that part of the investigation of allegations, such as what we've heard and whistleblower and that, we must exercise the process that we have. And we can't hold our government responsible if we're not using the investigative tools that's allotted to us. It seems to me that the allegations that I've heard here today, which are disturbing to me, are exactly the type of allegations that we need a third party to investigate.
That's correct.
Absolutely. And perceptions is hard to validate when you are not even giving the opportunity or reporting for that. When management fails to investigate themselves, the IG can step in as an independent party to carry out that investigation. Mr. Chair, I yield back my time.
Thank you. Now recognize the gentleman from South Carolina, Mr. Gowdy.
Thank you, Mr. Chairman. Mr. Harris, I made a note, the ranking member in his opening remarks said that sexual harassment was intolerable and had no place in the federal workplace. And I am, and if you heard him today and hear the passion with which he speaks on this issue, you'll know that if he were in charge, it would be not tolerated and have no place in the workplace.
That is correct.
But he's not in charge. And it appears to me that it is tolerated, prevalent, and really the only consequences are consequences for the victims, not the perpetrators.
That's right.
The chairman, whom I laud for calling this hearing, began to get into some of the specifics with you. And that's precisely what I'm going to do. No names, no identifying characteristics at all. But I want to know how many victims and witnesses to the harassing conduct were there?
From the top of my head, right now, I remember there were at least 10. I don't remember the specifics, but I do have it documented in the evidence that I submitted. But I do remember there were at least 10, we took 10 statements.
All right.
And
so there are 10 victims of sexual harassment. When did the conduct begin?
I was informed, as I said, we worked together. I was informed that the conduct started right around 2002.
All right. Now, we use the word conduct because it has such a benign-sounding name to it. I want you to describe for our fellow citizens what that conduct was. What did these victims have to endure?
According to the statement submitted by one of the victims, She endured the very same thing, the touching, the attempts at rubbing, touching her back, arms, legs, shoulders. This, if I remember correctly, according to the statements, happened to at least 4 of these women. They reported this, again, going back to 2002, and nothing took place. For this long, limited period, the manager involved was more hell-bent on saving the reputation of Dr. Bertram than he was in dealing with the issue. He himself stated to one of the victims, if I do something, it will ruin his reputation.
Well, I think he'd already done that, and to the extent that he had not, we're going to keep going. I read hugs, kisses, placing his hand on the knees of several women. Is that correct?
That is correct.
Rubbing their arms, upper and lower backs. Is that correct?
That is correct.
And again, this is going on since 2002?
That, yes, once we were made aware this has been taking place since 2002. We predict it might have lasted longer than that, but.
Well, let's just go with let's just go with what we know we can prove. 2002, we have a combination of victims and witnesses who were forced to watch this, whom I also consider to be victims, numbering 10. Gestures, remarks, and other sexual innuendos. What were some of the remarks and innuendos that these victims were forced to endure?
I remember in one conversation with one of the young ladies, they were at a meeting, and one of the innuendos were there was a couple of males who were bantering back and forth, and they were supposed to be on a ship, the Guardian, which is the EPA vessel, and they kept making references as to who they were going to poke.
So you have conduct dating back to 2002. You have double-digit victims. You have conduct that is, by any definition, sexual harassment.
Correct.
Now, I want you to tell my fellow citizens all the consequences that the perpetrator suffered.
The perpetrator, initially there was an issue for they were going to go ahead and give him a reprimand.
A reprimand?
For about the written reprimand, for about the 3rd or 4th time. When we stepped in and said, wait a minute, you got to do more than that.
How would you get a reprimand for this conduct? Is there any ambiguity as to whether or not it's acceptable? Is there any ambiguity as to whether or not it's illegal?
It is not acceptable and should not be. If you look at the agencies.
It's actually a crime to
agree.
touch someone when the touching is unwanted. It's actually a crime.
Yeah.
Well, I hope it gets remedied. This workplace environment is criminal.
Yeah, it's toxic.
And whatever consequences befall this perpetrator would be insufficient in my judgment. I yield back to the chairman.
Thank the gentleman. Now recognize the gentleman for Virginia, Mr. Conley, for 5 minutes.
Thank you, Mr. Chairman, and thank you all for being here. I think all of us ought to stipulate that sexual harassment in any form is wrong. In some cases, as my friend from South Carolina just said, it's against the law. Unwanted advances simply cannot be tolerable in the workplace. And it is the obligation of every agency manager within the Federal Government to protect the workforce from such unwanted advances. But I think it's important for all of you to also keep in mind that in this Congress, unfortunately, there is a clear agenda against the mission of EPA that does not want EPA protecting the public through regulatory process. And it is very important that as we excise out wrongdoers with respect to sexual harassment, that we keep in mind there is another agenda sometimes at work here, too. Of course, none of my colleagues here. And I don't know how many times, over 100, we've voted on the floor of the House to defang EPA, whether it be water regulation, air regulation, particulate matter, you know, we don't like it collectively, this Congress. And a word of caution in terms of what's, some might see another agenda going at work here. Now, let me ask Ms. Kellen, so listening to this and certainly listening to the formidable statements against the evil of sexual harassment, so sexual harassment is a pervasive part of the EPA culture, is that right?
I would not say it's a pervasive part. It happens in locations, and it is not appropriately addressed.
Right.
Bullying is more pervasive.
Bullying.
Bullying, which is as detrimental, almost as detrimental as sexual harassment.
Why do you think when it does occur, although it's not pervasive, it is not handled instantly? I mean, with you know, efficiently and rapidly, so we make a clear statement to others who might think that's okay, and frankly, to deal with the situation so the victim isn't lingering, you know, without an unresolved case. Why do you think that is?
I think most of the time, most of the managers, EPA employees tend to hang around a long time. And most of the managers have come up through the ranks together. And they just cannot imagine that Joe over here, Manager Joe, who is the nicest guy in the world to them, could possibly be treating their employees that badly. They're not listening to the employees. And I think there's a lot of pressure on senior leaders, and there are plenty of really good managers at EPA. But I don't think they have the support to stand up to other managers and do what needs to be done.
One, you know, H.L. Mencken once said that for every human problem, there's a solution that is simple, neat, and wrong. One of the solutions being proposed, floating around here, is actually to take away civil service protections from federal employees, virtually making federal employees at-will employees so that protections go away. Do you think that would be helpful in terms of trying to make sure we're excising sexual harassment from the federal workplace?
I think that would be a disaster. None of the people to my right would still be working for the agency if that were the case. They would have got them out of the agency so fast, none of us would have known what happened.
Mr. Tuttle, you're shaking your head. Yes, you agree with Ms. Kellen on that it would be counterproductive?
Yes, I do. I don't want to broad brush anything. I think that appropriate action needs to be taken on situations like this and others, and frequently it's not whether it's the culture of get along, go along. In my words, that I clearly belong to me, my attitude and viewpoint has been that management will do whatever it wants, when it wants, to who it wants, any way they want, any time they want, with impunity. And my colleagues,
you mean without civil service protection?
So I don't think so. Yes. So I don't want to broad brush anything.
Yeah.
But I do agree with Ms. Kellen that if the protections were removed, I can pretty much assure you that you and I would not be having this conversation.
Dr. Boland and Mr. Harris, I have very little time left. Do you want to comment on this question of the removal of civil service protections?
I agree with my colleagues to my left. This is a very serious situation.
Could you speak up,
for us.
Dr. Boland? I'm sorry.
I'm sorry. I agree with my colleagues on the left. It's a very serious situation for us to deal with. And if we were not to have that protection, none of us would be, neither of the three of us would be here today. So
thank you.
That's my response.
Very important testimony. I yield back.
Thank the gentleman. I'll recognize the gentleman from Georgia, Mr. Ice, for 5 minutes.
Thank you, Mr. Chairman. Ms. Kellen, you mentioned earlier that many people, employees at the EPA, just wanted to do their job, and if the managers could get out of their way, they would be able to do so. And just to counter a bit from the gentleman from Virginia, we're not talking about an agenda against clean air or safety or that type of thing, but there are many business owners out there, quite frankly, who feel the same way about the EPA as the people who are working there. They just want to get the EPA off their back and allow them to do their business without being bullied by the culture that is within the EPA. But I do want to go specifically to some of the issues you brought up regarding retaliation. There's been quite a bit mentioned in that regard here today. In your opinion, what kind of retaliation is there? We mentioned bullying, perhaps changing of positions, but specifically, what type of retaliation is there against people who report these type of things?
In the instance that I mentioned in my testimony, once the employee had filed her EEO claim, they decided to go on a fishing expedition and search through her email and go through her desk and try to find something that they could go after her for. And so that's one way. And really, when you look at the nature of the agency.
And what would they use that information, whatever they found? Would it be used in a blackmail kind of way, or what? How would they use it?
It was used to try to remove her from federal service.
Okay. All right, so it was an attempt to find something in order to fire her.
Exactly.
All right, I'm sorry, continue, please.
In other instances, I think the issue with the federal government is very easy because of the amount of, after the Beal situation, the time and attendance rules are very tight, and we're spending an extraordinary amount of money trying to enforce that against the rank and file employees. And so it's very easy to find a technical violation when someone is still doing their job. So the other forms of retaliation is not assigning the good work. People really are excited about their job. They want to do good work. And you can take away the high-profile cases. You can take away the good work and give them the kind of dredge of the work. And so there's severe and there's more subtle types of
But there's multiple types of retaliation. Dr. Boland, real quick, please.
Yes. The denial of workplace benefits and privileges is one way of retaliating. Harassment. Then you have the removal, the backdating of personnel actions to change the situation so that it appears to be what management wants it to be.
And you mentioned earlier specifically intimidation.
Yes.
So there's quite a bit of that. All right, how prevalent is retaliation in the culture of the
Mr. Heiss, may I address also that issue and that question, if you don't?
It would do so quickly. My time's running out.
The higher up you go, the more the retaliation. You have a go-along to get along mentality. You file one complaint, say something is wrong, there's now 25, 30 people you now have to watch.
Okay. All right, how prevalent is this?
It's very prevalent. The higher up you go, the more prevalent.
All right, so this is not, these are not out of the ordinary. These are not exceptions. The entire culture is a culture of you fall in line, you do as you're told, or you will suffer consequences.
That is correct.
Absolutely.
All right, now all of you would agree with that.
I actually might disagree a little bit because there are some managers there who really do support their employees and allow them to do their work.
That would be the exception.
Well, we're talking different regions, too.
No, not necessarily.
Not
okay.
necessarily.
All right, but it's not uncommon. Is it safe to say it's not an uncommon?
Right, and maybe I just come from a location that has better managers than they have in Chicago.
Okay, well, what are the options that a person has if they want to identify harassment or they've seen something that they want to report? What are the legitimate options given the fact that there is a culture of retaliation if they go forward?
Your options are diminished. But again, we talked about OIG, the perception or persona. And I think OIG would do an excellent job, but the persona, OCR. If you look at the new OCR policies that the agency just came out with, they just changed them. Now, you don't even contact the
What about the
OCR
person
officers.
who's there, though? I mean, do they feel like there are options, or do they feel like they just have to be silenced?
They feel like they have to be silent. Their options are
All right,
gone.
so they don't feel comfortable.
No, they do
No.
not.
Okay. Thank you, Mr. Chairman.
Thank you, gentleman. Now recognize the gentleman from Alabama, Mr. Palmer, for 5 minutes.
Thank you, Mr. Chairman. Ms. Kellen, you mentioned that if the EPA leadership fails to act on management complaints that were investigated by the Office of the Inspector General, then that could undermine the IG reporting system. This committee takes that very seriously. We've had a couple of hearings in which Arthur Elkins, the Inspector General for the EPA, has testified and talked about the impediments that they've faced in investigations, I think some specifically to what is being discussed here today. Can you elaborate on this concern from your perspective?
Absolutely. In one situation that I actually mentioned in my written testimony, the IG did an investigation of an employee. He was moved off into a small office. And then he was brought back up to the administrator's office. I've asked to see the copy of the IG report. I've talked to the former chief of staff to try to get an idea of what really happened here. And I was told he was exonerated, except for the alcohol charge, but I am not allowed to see the report. And so I'm not allowed to know whether he was actually exonerated from all these charges or whether the employees were just too afraid to talk to them. And there's a big difference there. And so by having these reports not shared, or not more open, we have no way, and the employees who anonymously reported this have no way to know that anything was actually done on it.
Are there other examples that you might cite?
Not offhand, but I am sure it has happened in other situations. But in general, we do not get to see the IG reports on these matters.
One other thing that troubles me about the culture at the EPA involves the Title 42 appointments by EPA. And they allow the EPA to pay well above the normal Title V levels, with salaries reaching $200,000, $300,000. That's supposed to be used to hire temporary consultants. Why does the EPA use this authority to hire managers when it's intended to attract top quality scientists and engineers?
In one instance, I was told that they use the authority because it takes so long to get an SESer in place, and that this was a fast, easy way to get a manager in there. But I also think that there is at least in some places, a culture of, frankly, nepotism-like behavior, where they have people that they know of, buddies from before, that they want to get into some sweet position that they can just kind of slip them in and let them do their thing.
And those people are protected?
They are not protected, really. They're protected by management, but they shouldn't be protected because they're term appointments. So it should be very easy to remove them, yet they don't.
Okay. Thank you, Mr. Chairman.
Thank you. Now I recognize myself. Mr. Cummings and I have just a couple follow-up questions, and then we'll get to the administrator. I need to understand the involvement of Susan Hedman. Have you any personal experience with any sort of retaliation from Susan Hedman herself? Mr. Harris, go ahead.
I do personally. I did not have contact with her directly. However, personally, yes, I believe she was definitely made aware of what was taking place. There's no doubt about it. If you read what Mr. Mather stated in his affidavit and in the depositions, he clearly stated he consulted with her. And once she was made aware of this, her statement in her own affidavit, I told him to handle it or I just want this to go away. The question with regards to my reassignment in the depositions that my attorney, Mr. Stool, took over, I'm sorry, Carolyn Boland's depositions. Again, the elusiveness, I just wanted it done with and over. And she signed our documents, but yet in the deposition she stated she didn't have anything to do with this. It was like she was above this. As the CEO of that region, how can you be above something of this nature?
Dr. Boland.
Mr. Mather stated on several occasions that he had consulted with Ms. Hedman and that they had agreed on certain negative aspects of what happened to me in the retaliation, like the removal from the OCR, like not allowing me to have the temporary medical flexi-place, episodic flexi-place. I was denied the workplace privileges and benefits, and also involved in backdating personnel documents, which I think is a serious issue. I see that her name was on those documents, signed those documents. So there was some involvement, yes.
Mr. Tuttle.
As I indicated in the statement I submitted to the committee, in December of 2012, when I returned from Christmas leave, my colleague and my labor relations supervisor told me that he had been informed by an attorney from the Office of Regional Counsel that Ms. Hedman had told Mr. Mather and Ms. Newton to get rid of me, and I use the term get rid of me colloquially, largely because of the sexual harassment case and my involvement in that, and how hard I was pursuing to see that management was held accountable for their responsibilities in that, as well as some other incidents that occurred that I alluded to in my statement, where I took a stand and said, no, this is not going to happen this way, and I became an impediment. So that's what I understand that she was involved in. As I indicated in my statement, that's hearsay on my part, but it was credible at the time given the circumstances.
And Mr. Tuttle, I haven't heard from you directly, verbally here about the intern X. What did you find? What did you hear? And were there other incidents that this Paul Bertram was involved with? What was your finding?
My findings were that in the statements that I had gotten, the written statements I had gotten from the not only intern X, but the other interns that I was put in contact with that submitted statements, a majority, not all, but a significant majority of those statements all indicated that the same type of behavior, the touching, the inappropriate contact, the sexual innuendos, the words, all of that the same. All of the statements that expressed that indicated that that intern had reached out to management, in particular the manager that was responsible, because they were all in the same branch within that division. And they'd reached out to this manager to get it to stop, and one of them made the statement that Mr. Harris brought up that said when she wanted something done about it, this manager, Paul Horvaton, said to her, well, you know, if I do this, it'll ruin his career. And as I indicated to Ms. Lawrence, to Congresswoman Lawrence, one of the other things that was said was that these women all asked for something to be done and nothing had been done. And to piggyback on what my colleagues have said here, all of this was made much worse than just being in the office, because all of these interns went out on our research vessel, Lake Guardian, onto Lake Michigan, because that's a normal part of what Region 5 does, because that's the national program for the Great Lakes. And sometimes they're out for days at a time. And so to be confined on this small research vessel while this is going on was a concern for the ones that I'd gotten statements from.
How many people and how far back did it go in the record?
My records I got statements that went back to approximately the year 2000. That would have encompassed about 10 statements, like Mr. Harris said, and probably all but, best I can remember right now, all but 2 had this same kind of statement made into them.
In your professional opinion, how would you categorize Mr. Bertram? Was he a predator? Was he a serial? How did you? I don't want to put words in your mouth.
Based on what was documented, that could conceivably constitute a serial predator. And you know, as I heard someone else make the statement, I can't remember where I heard it, but you know, this predator was being fed a steady diet of young interns over an extended period of time. And to also go along with my involvement, because as I indicated to the committee in my statement, I pursued this from the administrative side, and I was actively pursuing removal. And when Dr. Bertram was served notice, I guess, of his proposed removal, he retained an attorney, and from what I was given to understand through my labor relations supervisor, Mr. Gil Colston, once his attorney, because we provided support documentation as part of the due process, once his attorney saw what evidence we had that we were using to justify the removal, the attorney supposedly came back to Mr. Mather and asked if Mr. Mather would let him retire in lieu of removal. Now, Dr. Bertram had sufficient service for regular retirement at the time the removal was proposed. I was not proposing to do him out of retirement because that wasn't within my purview. But by removing him, I could have added a few extra months and steps into him getting his retirement. Instead, in my professional opinion, when Mr. Mather agreed to let him retire, he gave him a free pass out with no blemish. So he had done all these things and essentially walked free.
Was there any discussion about a criminal referral? Because in my opinion, Mr. Gowdy's opinion, what he did was illegal.
What he did was absolutely illegal. I don't know if discussion was held between Mr. Mather once the matter was brought to his attention and the regional counsel, Mr. Kaplan, who is now the deputy regional administrator since Mr. Mather retired. I don't know if discussion was held on that or not. I can't testify to that.
Dr. Boland, seemed like you wanted to add something.
Yes, I just wanted to interject something. It seemed as though Susan Hetman made herself involved in the Glenpoe program, the Great Lakes National Program. As a result, I think of an enormous grant that was given, and Dr. Bertram was a scientist that was very, very important in completing the projects involved in that Glenpoe grant. And I think that they were trying to hold on to him for that reason specifically until some of the work was, either transferred to someone else or that he was able to at least get involved with cleaning up some of the project.
So what you're saying is it was more important to the EPA to get the grant money and to get the grant done than it was to hold him accountable for the...
Yes, it was. At the hands of Ms. Hetman.
It's disgusting. Absolutely disgusting. Now recognize the gentleman from Maryland.
Thank you very much, Mr. Chairman. I just have a few questions real quick. Let me say this. I assume this is being streamed to EPA probably. And all of you out there in EPA land, let me tell you something. We've had these courageous people to come before us today, and I promise you that if you try to retaliate against any of them, I will do everything in my power to come after you. And I really mean that. I do not want anything to happen to these folks or any other people who are bravely coming forward, trying to simply do their job, just doing their job. Mr. Tuttle, if it were not for all of this, do you think you'd stay in service? In other words, you've been kind of forced out, but would you have rather to stay in service?
Well, to answer the question directly, yes. I like what I'm doing. I believe I've always been in customer service positions. I like what I do. I enjoy helping people and helping the mission get done. Because of all of the things I've done, I'm not only facing a force out in December, I've been reduced in grade from a GS 15, which is what I was in Chicago, to a GS 14. I've been removed from supervision. I'm not allowed anywhere near anything to do with what I formerly did, at least certainly anything where I can contribute at the level I have expertise in.
Have any of you all ever talked to Administrator McCarthy? Any of you directly?
No.
I have not.
No.
She's going to be sitting where you're sitting in about 5 minutes. What would you, since you're not going to be asking questions, what would you want us to say to her? And how do you think that she can help you do your job? Because you're not, we're going to have that opportunity. You won't. This is your shot. I'm listening. Mr. Harris?
I would like to see the very first thing, who are you going to hold accountable? Yes. And I don't just mean accountable with a slap on the wrist or another reassignment, and then you get promoted a year from now and get a big federal award. Who are you actually going to remove from federal service as to what occurred to us?
By the way, she's probably watching this right now, but go ahead.
That is my question with her watching. Who are you going to remove from federal service?
All right, Dr. Bowler.
Yes, I think that disciplinary action is necessary for those who are violators, of federal policies, rules, and regulations. And I think that accountability, as Mr. Harris said, is very, very important. There should be some type of stringent action coming from the top down to reinforce the fact that retaliation, sexual harassment, discrimination, and the like will not be tolerated here. And I think that will be done through example.
Mr. Tuttle.
I agree with my colleagues. I think accountability that's held firmly to is the only answer. I think that retaliation in any form, regardless of who it is, whether it's me, any of my colleagues, or anybody else, is abhorrent and has no place in any organization. So if I were going to say, I were going to ask a question, it's, are you going to take a stand to make sure that me, my colleagues, and people like me can speak out on issues that need to be brought into the light of day, and we're not going to have to worry about whether we're going to end up out on the street or castigated or marginalized or shamed any more than we've already been.
Ms. Kellen.
I want the administrator to do what the head of VA recently did and go to us, the unions, and work with us so that we can identify the problems, because we know where they lie, and we will be very careful about not identifying people who are not the problem. We will identify the problems, and they need to address them.
Now, one thing that Ms. McCarthy may say is that EPA issued a notice of proposed removal of Dr. Bertrand within 2 months of the March 2011 incident. Is that accurate?
That's accurate, but only after we got involved and completed a fact-finding investigation. Initially, they were going to give another reprimand. When we met with Mr. Mather and told him, you can't do another reprimand.
I'm running out of time, unfortunately.
That's when it changed.
But let me just say this as I close. I want to thank you for what you have said. And I gotta tell you, my chairman here is a lot younger than me. But as I get older, I realize, Mr. Harris, that 15 years ago, 15 years from now, I may be dead. And what you are doing today, it's not just about this moment. And it's just not about the people there right now. It's about generations yet unborn. It's about people who are in high school right now.
Right.
Little kids in the 6th grade.
Yes.
Who simply want to give. They don't want to make a lot of money. They just want to make things better for all members of our country. And so what you are doing, what you have done, it goes beyond, hopefully it goes beyond the grave. And so I want you to keep pushing forward. Mr. Tuttle, I'm so sorry that you are being forced out of government, because you all are the kind of people that we need.
Yes, he is.
You're the ones that we need. But yet and still you're forced out, simply trying to do the right thing.
Yes.
We're better than that. Thank you, Mr. Chairman.
I want to thank you all for being brave enough to come here and testify. It will make a difference. We do listen to what you have. We do want to continue to follow up with you, and I concur with a ranking member here. The passion that he puts into this and the caring that he has, we all appreciate. And you keep us up to speed, and we got your back. We're going to stand in recess for approximately 5 minutes by reset, and then we will start our second panel with the administrator.
Thank you so much.
Thank you. Thank you.
Thank you.
Committee will come to order. We're pleased to welcome the Honorable Gina McCarthy, Administrator for the Environmental Protection Agency. And Administrator, we appreciate you being here. You have regularly testified before Congress. You have made yourself available, and to that we're very appreciative, as I know other committees are. It's not always an easy thing to come and testify before Congress, but I do believe it is one of the unique things and great things about the United States of America, the way we operate. We have these discussions with candor. We ask tough and difficult questions. It is part of the checks and balances, and your personal involvement and participation is very much appreciated. We recognize that, and we thank you. And as you know, pursuant to committee rules, witnesses are to all be sworn before they testify. So if you would please rise and raise your right hand. Do you solemnly swear or affirm that the testimony you're about to give will be the whole truth, the truth, and nothing but the truth? Thank you. Let the record reflect that the witness answered in the affirmative. We would appreciate it if you would limit your verbal comments to 5 minutes, but we'll be very generous with that. And of course, your entire written statement will be entered into the record. Administrator McCarthy, you're now recognized for 5 minutes.
Thank you, Mr. Chairman, Ranking Member Cummings, and members of the committee for the opportunity to testify today. It really is an honor to serve as Administrator of the U.S. Environmental Protection Agency. EPA's mission to protect public health and the environment is important to every one of us and our families, and I understand and appreciate the committee's keen interest in EPA's work. In order to best achieve our mission, one of the priorities for my tenure as Administrator has been embracing EPA as a high-performing organization. That means using our limited resources effectively, supporting our incredibly talented and dedicated workforce so that EPA employees have the tools that they need to do the important work that we all ask of them every day, as well as ensuring that the agency continues to rely on a faithful application of the law and science. The overwhelming majority of approximately 15,000 EPA employees are dedicated, they're hardworking, they're professional public servants. I personally remain very proud of both the EPA's achievement in protecting public health and the environment on behalf of the American people and of the EPA employees who work hard every day to make those achievements possible. But I also know that over the last few years there have been examples of a few EPA employees who have engaged in serious misconduct. While I firmly believe these employees are isolated examples, I believe we always can and must do better. To that end, we have made a number of changes to agency management processes and procedures, and we will continue to strive for continuous improvement in this area. While not the subject of today's hearing, with the committee's encouragement, we have been working closely with our Inspector General to enable the agency to expeditiously take administrative action with regard to certain types of employee misconduct. The agency and the OIG have now biweekly meetings to discuss the status of those investigations into employee misconduct, and we have agreed upon a set of procedures and timelines for information sharing in certain categories of cases. These meetings and procedures have helped us facilitate the agency's ability to take action more quickly upon completion of the OIG investigations. The agency and the OIG sent a joint letter to the committee outlining this progress earlier this year. As I understand it, today's hearing is focused primarily on the events surrounding a misconduct situation which occurred in 2011 at our Region 5 office in Chicago. While the misconduct that's at the root of this case occurred before my tenure as Administrator, it's my understanding that in this particular case, a Region 5 supervisor took action upon learning of the alleged misconduct of the individual, and that individual was subsequently held accountable and no longer works for the agency. While there were some difficulties and likely some miscommunications among the officers in the region, which may have created confusion among those involved, through the efforts of all involved, disciplinary actions were taken that resulted in the subject employee no longer being a federal employee. I expect all managers to take appropriate corrective and disciplinary actions when they learn of potential misconduct by one of their employees, regardless of that employee's position at the agency. Harassment of any kind in EPA workplaces is intolerable. In December 2014, I reaffirmed the agency's commitment to prohibit harassment in the workplace through an email to the entire agency. In January, I sent a second agency-wide email reminding everyone of the OIG's important role in rooting out waste, fraud, and abuse at the agency, ensuring employees were aware of their ability to contact the OIG hotline about a matter. The agency also recognized the need to provide managers with clear guidance on what to do if they become aware of alleged matter of harassment. Earlier this year, the first ever comprehensive set of procedures evaluating allegations of harassment were developed and sent to the agency's 5 units for bargaining. When those discussions are concluded, we will finalize the order that formalizes the agency's very first procedure for addressing allegations of workplace harassment. The order will provide for uniformity and transparency about expectations related to processing complaints of harassment, procedures for reporting and responding to those complaints, and guidance for engaging in related fact-finding and decision-making. We hope to conclude this process in the very near term. Having formal procedures to implement the agency's anti-harassment policy will provide the clarity we need for managers and employees in preventing and stopping harassment of any kind. In closing, I'm honored to serve this agency and the people of the United States. I'm proud of the great work accomplished every day by all of the employees at EPA, and I'm excited about the progress we're making as an agency. With that, I look forward to taking questions.
Thank you. Now recognize myself for 5 minutes. Do you believe the 3 witnesses that were here prior, do you believe they were retaliated against?
No, I do not.
Not in any way, shape, or form?
You know, I think that, Mr. Chairman, I want to just confirm that harassment of any kind isn't tolerated. You know, as a 61-year-old woman who started in a man's field,
this is not the question I asked you. I want to know about your background. I want to know if you think that they were retaliated against.
No, sir.
We heard nearly 2 hours of testimony, and you believe that their statements are false.
No, I did not indicate
Well, they said that they were each retaliated against, and you said that's not the case.
I indicated that what I look at is the entire facts around the case. And clearly, we had confusion in how we investigated it, but they were part of a large team that actually recommended removal of that employee, and they are no longer in federal
And part of the
service.
criticism—
There was nothing to retaliate, and retaliation will not be tolerated.
Mr. Tuttle has a lower grade, less responsibility. You don't think that that was a result of some of his complaints against management?
There were issues long before the issue of sexual harassment that arose about Mr. Tuttle's performance that's well documented, and he still is a productive and valued member of EPA's.
What is your definition of sexual harassment?
It's the same as in the law, sir, and any harassment or bullying is not tolerated at EPA. This is not a question
When you say not tolerated, they have documented multiple cases, up to 10 times, of sexual harassment against this intern. Did you ever do—
I think, sir, if you look at the entire record, you'll see that these are regular performance issues that we have resolved separately. It is not a retaliation.
Was there any criminal referral?
Was there any criminal referral? In this
The answer is
particular
no,
case,
and I want to know—
I don't believe so.
You said that the definition of sexual harassment, you agree, is what is in law. So if it's illegal, the kissing, the touching, the inappropriate behavior is against the law, why didn't you refer that for criminal prosecution?
It was properly referred to the correct agencies within the agency.
Which agencies?
The Office of Human Resources in that region.
That's within your own agency. It's against the law. It's not against your own policies and procedures. What these people testified to is they had to step up, go to the mat, and say, offering a reprimand is not sufficient. I want to know why somebody—
The employee was removed, sir, not reprimanded. He was removed from service.
But the problem is they had 10 victims to get to that point. Now, granted, you are not the administrator the entire time. I understand that. But this predator, the quote we heard, this is a predator who was fed a steady diet of interns. The first time it should have happened, he should have been fired, and he should have probably been referred to the authorities for criminal prosecution. It happened 10 times, and you never did that. You still haven't done that in this person.
I am aware that 11 years ago there was an issue raised, and it was handled appropriately, as my
Appropriately, he got a promotion. He continued to work there.
He was carefully watched the very minute we had any
Who's watching him?
indication-
Who's
The very
watching
minute
him?
we had any indication of impropriety, which was the recent issue, we took prompt action, and in less
You
than
moved
2
his
months,
cubicle
that man left federal service.
You moved his cubicle 4 4 spaces away. You think that's appropriate? What do you say to the mother and father who sent their 24-year-old to the EPA? She's starting her career, and she's harassed. Look at her statement. And you did the appropriate thing by moving her 4 cubicles
Sir, we
away?
are doing everything we can to reinforce the policy and the law. We are developing procedures so there's never a question about this, and we are doing everything
That
we
isn't good
can
enough.
to protect
When
every
somebody is
employee in the
sexually
agency.
harassed, you send them to the authorities. You fire them.
I did send them the correct authorities.
You sent them to Human Resources, who wanted to reprimand them. You never did send them to the criminal
Human
referral.
Resources recommended the same thing as every manager, which was to actually proceed to removal. The man is no longer in federal.
That's not what initially happened. He was in his record that they had had 10 complaints, 10 sexual harassment complaints against this gentleman, and he was allowed to continue to be there. And as we heard testimony, a predator who's fed a steady diet of interns.
I am aware of one complaint 11 years ago, and the complaint that was just processed under my watch, which resulted in his removal from public service within 5 or 6
Did you
weeks.
fire him, or was he allowed to retire?
He was allowed to retire because that is his right.
Yeah.
Even if he were fired, he would be allowed to retire.
Do you believe that this intern who said that there was sexual harassment, do you believe that her statement is true?
Oh, I absolutely do, and that
Then
was
why didn't you
actually the
refer it
joint
for a criminal
agreement that
referral?
everybody came to.
Why didn't you give it as a criminal referral? If you believe that her statement is true, and it was sexual harassment, and that is a violation of the law, why, and you allowed him to just retire, why didn't you send that to the proper authorities?
We took the appropriate action.
Do you think it's appropriate? Do you think it's against the law to sexually harass somebody at work?
I think it's not only against the law, but it's also against our policies, and we acted under the policies and the law when it led to the removal of him from public.
Did you let any of the law enforcement officers know?
Mr. Chaffetz, I have 2 young daughters just about this woman's
I got
age.
2 young daughters too,
appreciate
and
the
I would
fact-
never send them to the EPA. It's the most toxic place to work I've ever heard of. This person, this 24-year-old girl, she's starting her career. She's harassed over a 3-year period. And you admit that that is a violation of the law. Why didn't you do the criminal referral?
There was absolutely no information that I was aware of, or that the people investigating this when this intern spoke up, that there was any consistent harassment until the day she spoke up. I am not blaming her. She is in a very difficult situation that none of us want her to be in.
When she did speak
But we
up.
can't
When she
know
did speak
things
up.
that have never been, when things aren't spoken
Looking
up.
at the record now, are you going to do a criminal referral? You got to ask somebody. You're the administrator.
Well, I'm happy to move forward in whatever
You're
direction
happy.
people
I don't want you
do.
to be happy. I want you to do the right thing. He should have been fired. And at the very least, you should do a criminal referral. How many times does this happen and you don't do a criminal referral? I mean, we had the case where we had to bring you up and talk about Mr. Jutro. So why is there such a toxic environment? I want to know why there's no criminal referral. You didn't do it then, and you're not willing to do it now. Why?
The individual could have. We responded appropriately under our policies and the law. If additional work is necessary or referrals, we're happy to do that. I didn't make a decision that this shouldn't move there. I operated under the policies and the law to move forward. And in fact, we expedited this in a way that Mr. Cummings has been asking us to do for a long time.
Do you believe-
which is quickly and decisively.
Do you believe you have an obligation under the law, if you know of sexual harassment, to report that to the legal authorities?
I'm not aware of that obligation, no. I am aware that we have to follow it up and appropriately take steps that are appropriate for the circumstances, which is exactly what we did.
Your appropriate steps were to move them 4 cubicles away. Do you think that was appropriate?
No, my step, and the step that led to his removal is what I'm referring to. I do not know what you're referring to in terms of
I've given you probably a dozen chances to say, and I'll give you one more time before I recognize Mr. Cummings. If you have knowledge of criminal activity, do you believe you have an obligation to report that to law enforcement?
I did not treat this as a criminal activity as opposed to an appropriate anti-harassment issue. That's how it's worked. That's how it's done.
And that's the cry and shame. Because you know what? Sexual harassment, it is a crime. And you need to take it more seriously. and it needs to go to the legal authorities. And that's the failing on your watch, on what you're doing.
Part of the challenge, Mr. Chair, is I am happy to talk to the woman involved, but part of the decision is that that woman chose a number of different paths she could take. It is always open to her. Frankly, I'm not comfortable making decisions for a young woman who probably wants to move on when I have already taken all of the actions I can do under my own authority.
You didn't separate
And I'm
them.
not sure
You
you
didn't move
should
away.
make that decision on her behalf either.
Anybody who looks at this case, you fell far short of that. I now recognize the gentleman from Maryland, Mr. Cummings.
Thank you very much. McCarthy, I just want to see if we can't, you know, I don't know how much of the testimony you heard earlier, but you had 3 whistleblowers, all 3 of them are still in the room. And they were very, first of all, they were very courageous. They were people who came before us. They didn't have to do it, but they did. And they talked about problems that the chairman had just alluded to. And I want us to be very careful that we're not so busy being defensive that we don't address the problem. I tell my staff that I'm about the business of being effective and efficient, period. Life is short. And so I'm trying to figure out how do we address these issues effectively and efficiently so that we're not in a situation that Mr. Harris found himself some 15 years ago talking about these same things, and now he's back again today talking generally about these same things. Mr. Harris, the former EEO manager in the Office of Civil Rights, Region 5, testified about his experiences with what he believed to be retaliatory conduct by management. Specifically, Mr. Harris alleges that in 2011, as a result of investigating claims of sexual harassment, among other things, he was reassigned to his current position as EEO specialist. As a result, Mr. Harris, of his experiences, he offered 4 recommendations for bringing about positive change to EPA's work environment. And again, these are dedicated employees simply trying to do their job. These are the kind of employees that ought to be up for merit, for awards and, commendations. And I'd like to get your take on each of his recommendations. Mr. Harris contends that the EPA Council currently act as personal counsel for senior officials. He said this, and I quote, undermines agency policies and federal statutes enforced by EEOC. He recommends that this committee, and I quote, examine the roles of the agency general counsels with regard to allegations of Title VII violations and counsel's premature involvement in EEO complaints. Madam Administrator, how do you respond to that recommendation?
Mr. Cummings, any recommendation that a dedicated employee of EPA wants to make, I'm going to look at, period. But I will explain a couple of things. In our council office, we have a dedicated independent unit that specifically is there to support OCR and EEO complaints. They are independent of all of the other lawyers in the office and act that way. We also have an Office of the Inspector General, who I think this committee, above all others, will know is extremely independent. We do not always agree, but they do their jobs well, and they push us to get better all the time. And we need to respect that they're available. There's also an Office of Special Counsel that's available external to the agency, specifically as an independent body to support these issues. So there are layers of opportunities here that folks have, and I'm happy to explain that to them. And if that is inadequate, I'll listen to what else they might recommend that we do.
Well, I'm going to go to Mr. Harris's other recommendations, but one of the things that I said to the chairman is that I really wanted the IG to look at all of this, because I think perhaps, and you may not see it, but it sounds like there's a culture problem, at least in some of the regions. There's a culture problem. And that culture problem probably has developed long before you even got here. And sometimes that culture can be so thick and so, I mean, it's so deep that you almost have to dig it up and to really effectively deal with it. So I'm hoping that we will have the IG look at this. Mr. Harris recommends, I'm going to go to the second recommendation, that we have an ombudsman's office, which should have, quote, the utmost authority over personnel-related issues as they relate to Title VII violations. Administrator, what is your view on the need for a regional ombudsman's office with authority to oversee Title VII claims?
I certainly will take a look at it. I can't say that I'm familiar enough with the role of an ombudsman and how that interacts with other legal statutes and requirements, but I'm happy to take it back, and we'll come back to you.
I would ask that you, how soon can you get back to us on your thoughts with regard to that?
If possible, maybe I could have our staff work together and develop a reasonable schedule that you'd think was appropriate.
Very well. Next, Mr. Harris suggests that the federal EEO employees currently do not have sufficient retaliation protection. So he proposes that the EEO devise, quote, well-defined penalties for managers who retaliate against those who work to uphold an agency's EEO mission. I believe that you will not tolerate retaliation. There is no member of this body that would go along with people being retaliated against. As a matter of fact, all of us have worked very hard on both sides of the aisle to protect whistleblowers and those who might come before us from the agencies. But I just wanted to know your view on that.
Well, certainly we want to move forward to make sure our anti-harassment procedures are in place so that it avoids confusion, because I think part of that really led really good individuals as well as 2 managers into a difficult situation. So we'll get those done, and that will help. But the idea that we would provide sort of uniform measures really negates our ability to look at each case on its own merits and give each employee, whether they're a manager or not, their due process, which just is important to me, to make sure that we do thorough investigations and do this with due process.
Well, you'll never get me to argue against you with regard to due process. I think the problem is that when people feel that they are walking up against brick walls, when they try to get the word out and try to complain about situations, and by the way, and trying to do their job that they're sworn to do, then I mean, then they wonder about any process.
Well, the issue, I think part of the issue that I'm hearing is the sense that there's a double standard in the agency.
I'm glad you said that.
And
I'm glad you said that.
I'm working hard to make sure that that's not the case, and that's what these policies and procedures are about. But honestly, this has not been raised as an issue to me, and I'm really surprised that people don't find that the OIG is independent and effective in looking at these issues.
Well,
I would welcome that.
Well, it goes back to, now, Ms. Yellen, I don't know if she's still here, Ms. Yellen was telling me that she does have a relationship where she's able to talk to you.
Yeah.
And one of the things that she said in her testimony, and I think it kind of summarized this whole hearing, she said the rank and file basically gets screwed. And the management, some of the management folk, and she admitted that there are a lot of good management people now.
Good.
But that there are some that even when they do the wrong thing, they get the bonuses. They get promoted. And there's something wrong with that picture. I mean, it seems like that would smack morale in the face, big time. Would you agree?
Absolutely.
So I want you to do me a favor. I want you to, I mean, I know you want to come before us, and I'm almost finished, Mr. Chairman. I know you want to come before us, and I know you want to make sure you defend your agency. I got that. But I want you to also put some binoculars on, or at least look through a high-powered microscope and say to yourself, why would somebody who has been, these employees who have been here many years, giving their blood, sweat, and tears, why would they even risk coming here if they did not have something legitimate, or at least they believe legitimate, to say? They're putting themselves on the line. And I'm telling you, I could not be in your shoes and just disregard folks who put themselves in that position.
Well, Ranking Member, when the issue in Region 5 that the chairman was referencing involves what I consider to be very valued and successful members of this agency. I am not disputing their value or my willingness to work with them as continued wonderful employees at the agency. There was clearly a problem. The question I was asked was whether it was directly retaliatory, and my concern is that this committee needs to see the entire record.
I do want to see the entire. That's why I want to see the IG. That's why I want the IG to look at it.
So I think it's just important, and not because I'm disputing how they feel,
right,
but just what the facts are on the ground. And I will continue to work with these employees and others. Now that I know that there's a concern here, there will be no stopping our ability to work together. The unions are our partners. We're going to make sure that happens.
Now, either you can refer to the IG, or we can refer to the IG. But
I'm happy to request it. I'm happy to, sir.
Will you do that?
Yes.
And Administrator, please hear me out.
Yes.
Administrator, I don't know how long you're going to be in this position, but what we're trying to do is create a situation where we try to cure some of this so that people coming behind us will not have to go through the same thing. I mean, it makes no sense.
And I agree, and I am certainly not trying to be defensive of the agency, just defending due process for everybody involved, and I will work hard on this, Mr. Chairman.
And I want to make it clear, Mr. Chairman, and I know the Chairman agrees with me, that we know that the vast majority of EPA employees are great people, giving everything they've got. We've got that. But we don't want to ruin their spirit. We don't want to take away from them. We don't want to be forcing somebody out like Mr. Tuttle, who almost in tears, when I talked to him after the hearing, he does not want to leave, but he's being forced out. And you know what he said to me, and I hope you don't mind me sharing this, Mr. Tuttle. He said, you know, I'm 63 years old. Everywhere I go, I'm pretty much blackballed. I can't get a job. Why? Because he simply was trying to do his job. We're better than that. We are so much better. But thank you, Mr. Chairman, for your indulgence.
Thank you. I recognize the gentleman from Arizona, Mr. Gosar.
Switch it up a little bit, since I haven't had a chance to evaluate some of the things. Administrator McCarthy, there was a memorandum prepared by the Senior Army Corps of Employees detailing serious legal and scientific deficiencies with the Water of the United States rule were reported in the news this week. Are you aware of those memos?
I have been reading about them, yes.
Okay. Are you aware of the legal and scientific deficiencies raised by the Corps in those memos?
Just from what I've read, I have not seen the memo myself.
Mr. Chairman, I'd like to submit the memos and the attachments into the record and share some of those concerns with you right now.
With hearing no concerns, without objections to order.
An April 27, 2015 memo from Major General John Peabody, Deputy Commanding General for the Corps Civil and Emergency Operations, states, and I quote, "The rule's contradictions with legal principles, general, multiple legal and technical consequences that, in the view of the Corps, would be fatal to the rule in its current form. As is, the rule will be legally, quote, vulnerable, difficult to defend in court, difficult for the Corps to explain or to justify, and challenging for the Corps to implement," end of quote. The rule has abandoned principles of sound science, quote, and introduced indefensible provisions into the rule. A May 15, 2015 memo states, EPA's analysis underlying the rule is, quote, flawed in multiple respects, and the Corps' review could not find a justifiable basis to the analysis for many of the document's conclusions. Now, question, this rule was jointly issued by the EPA and Army Corps, is that correct?
That is correct.
Assistant Secretary of the Army Joanne Darcy testified before the House Transportation Committee in June that the Army Corps, quote, took these concerns and walked through them with the EPA before finalizing the rule. Is that your understanding?
That is my understanding, yes.
Can you confirm that the EPA knew about these concerns before finalizing the rule?
Since I am not privy to the exact language in the memo, I can't speak directly, but I can tell you that in working with Joellen Darcy on this rule, she indicated that all of the concerns of the Army Corps had been satisfied in moving forward with the final. I individually had conversations with her about the changes that the Army Corps was interested in making as the proposal moved through the interagency process, and I understood that everything had been fully satisfied.
Really? The EPA has publicly stated that it worked closely and carefully with the Army Corps to make sure, just as you said, sure that all concerns were addressed before finalization. In its April 27, 2015 memo, the Corps asserts that, to date, the fixes have not been adopted, so the flaw remains. Did the EPA adopt the Corps' recommended changes to the final version of the rule published on June 29, 2015?
I wasn't privy to the exact interagency discussion within the Army Corps. I was privy with, I had a close working relationship, as did our staff, and that's what produced the final rule, and I understood that all concerns were satisfied.
Well, that's why these two documents come out here showing the quite contradiction, because they're saying that they weren't met. Once again, I see the EPA saying that they're above the law, not only in rulemaking, and you're aware that there are numerous Supreme Court rulings that defy you actually going into the waters of the U.S. application. You got serious comments in regards to the Army Corps of Engineers that you're supposed to team up with, and yet you sit here and tell me that we've made sure that it's all taken care of, but yet it's not. What am I supposed to believe when I hear just the testimony that you gave in front of the chairman, and now I'm looking at waters of the U.S.? It's just a blatant disregard for the rule of law. Do you have any comments in regards to that?
I disagree with that, sir. I think it follows
Oh, you can disagree all you want, but the facts are the facts, are they not, ma'am?
They certainly are.
And so there's huge deficiencies with this rule. But yet you didn't take the time to move it forward, to do it properly. What you did is you forced it down just like everybody else does within this agency. And so who cares about the rules? You know, I come from Arizona, where water is for fighting over, whiskey's for drinking. So these are very, very important to us, particularly in the West.
They are.
And they're overreaching beyond that. So I find it very defiant of you sitting here and in light of these two documents, stating that you actually worked with the Army Corps of Engineers, that it's ingrained within the rule, but it's not ingrained in the rule. And you perpetuated a bad rule that has legal consequences and has ramifications for states and water use throughout this country. Shame on you. I yield back, Mr. Chairman.
Thank the gentleman. Now recognize the gentlewoman from Michigan, Ms. Lawrence, for 5 minutes.
Ms. McCarthy, Administrator, I am here today to talk about your responsibility as the administrator of this department. You have been in this position 2 years, correct?
That's right.
And the incidents we're referring to happened before your position took over this department.
That's my understanding.
So my question to you is, and I know that you understand this, because when you take on a position of a department head, you have responsibility for ensuring that your employees are safe, that they work without discrimination. Title VII clearly outlines what that discrimination is. And one of the ways that you hold employees accountable is that you train them, that when you come into a department that you have documented training that explains to all of your management staff that violation, that these are the laws, and you are held responsible for that. Can you explain to me how you, in these 2 years, have documented that your managers have this training and the accountability that happens as a result of that?
I certainly can, and I'm happy to provide a more complete report after the hearing. But we have had anti-harassment policy in place. People are trained in accordance with all of the policies. When an issue arises, one of the first things we look at is ensuring that they've been properly trained and that there will be no repeat of any violating behavior. You know, we take these issues incredibly seriously, and one of the things that's happened under my tenure is a continued increase in our training budget, not just for managers, but for other employees, so that people can know what their rights are, know what the appropriate recourse is if they feel like they have had issues that arise that they're uncomfortable with or they don't understand. And I think we're going to keep trying to do the best we can to both document training, but to increase training availability. It's been very difficult at the agency to adjust to budget cuts, but the last thing I am going to do is disinvest in the employees of this agency.
Now, the training goes two ways. So you train your managers, but you also train the employees.
That's right.
I was disheartened to hear that the testimony of the previous panel, where they felt they didn't have anywhere to go. To me, what came to mind, if they had been proper training, you're required to post information. If you feel like you're being discriminated, there's a confidential number that you can call that's beyond your manager if you don't feel. Are all those things in place?
I believe they are, but I will go back and double check. I think I'm distressed by the same issue. It seems as if they knew the Office of the Inspector General was available, but didn't feel comfortable or that they would be independent. You know, Art and I will talk about that and figure out what else we do. But there is training. People know who to call. One of the things we're working on anti-harassment is, while we've had a good policy, I think we haven't had the procedures in place to implement that consistently and effectively, which is why we just did that. I just asked that that policy be developed. What happened is the five unions wanted to bargain on the implementation of that policy. That's where we are today. My hope is that that will provide added clarity, and we'll integrate that into a more rigorous training program as well.
I want to be really clear. The question that was just asked by my colleague is about efficiencies in programs and procedures within EPA. I am the ranking member on Interior. EPA is extremely important to our government, to our environment, something I'm very committed to. This whole hearing is about distractions, about waste of time and demoralizing employees that we need energized and committed to actually doing the job we hired them to do. It is unacceptable that we have 11 complaints put forth on the same issue about sexual harassment, about bullying, and to your credit, 2 years in, but you must have a fierce commitment to policies, to making sure that any employee, if they feel like they've been discriminated with, that they know where they can go, that the IG, you don't wait for the employee to call the IG. You energize the IG to advise you. You need to do something above and beyond. You need to be creative as the administrator, how you're going to change this, because I am holding EPA accountable to do what we hired them to do. It's a critical time in our country with our environment and these questions, our water, for us to be so distracted. This, to me, is so disappointing that we have to spend this much time when we have valued 30 years experience in EPA is something that we should be valuing. That employee should be so energized and integrated into the success of this country and doing the work for EPA. And with that, I yield back my time.
Thank you. We'll now recognize the gentlewoman from Wyoming, Ms. Lummis, for 5 minutes.
Thank you, Mr. Chairman, and I certainly admonish you to listen to the chairman and the ranking member and the other members of this committee who have brought to your attention how serious this committee believes this issue is. With that, I too am going to switch gears. I want to talk to you about a couple of substantive issues related to the President's Climate Action Plan. Now, under his plan, the EPA has proposed 2 major rules on existing power plants and on new power plants. These rules affect listed species. Now, let's go to the Endangered Species Act, where any federal agency that carries out a discretionary action that may affect a listed species or critical habitat must consult with either the Fish and Wildlife Service or NOAA fisheries. The threshold's really low. It's any possible effect, including insignificant or beneficial effects. That's what triggers the consultation requirement in the Endangered Species Act. Now let's turn back to the existing source rule. The EPA just summarily concluded that the rule would have no effect on any listed species. In the new source rule, the EPA did not even address compliance with the Endangered Species Act. My question is this: will EPA consider whether its proposed new source rule may affect any listed species or critical habitat?
Well, Congresswoman, first of all, I'm glad of the commitment to endangered species, and I share it. We will make sure that the final rules actually meet our obligation under the Endangered Species Act.
Well, I hope that obligation includes a consultation, because with regard to the existing source rule, every model EPA has released projects that multiple coal-fired power units will close if the rule is implemented. Now, among those are Big Bend Power Station and Crystal River Power Plant in Florida. Now, according to the Fish and Wildlife Service's Florida Manatee Recovery Plan and a USGS study, the warm water that is provided by these plants is crucial to the existence of the Florida manatee. The plan states that about 2/3 of the manatees in Florida rely on these warm water discharges for protection from the cold. The plan states that alterations to power plants will significantly affect the manatee's ability to survive cold temperatures. Many of the power plants in Florida even have manatee protection plans embedded in their Federal Clean Water Act permits for water discharges. Now, that includes, like, Big Bend and others. The operator of Big Bend Power Station, Tampa Electric Company, has advised the Public Service Commission in Florida that your existing source rule will force the company to shut down Big Bend. How did the EPA conclude that its existing source rule will have no effect on endangered species if the EPA's own modeling and the Tampa Electric Company have both concluded that the rule will shut down generating units at this plant and eliminate the warm water refuge for manatees?
Well, Congresswoman, as you know, this issue has arisen during the proposal period for 111D. We will certainly take a look at this comment, and we will abide by the law as we finalize the rule.
Have you ever contacted the Fish and Wildlife Service with regard to the possible effects of the two power plant rules on endangered?
I can only speak to my own knowledge, which I personally have not.
Do you know if anyone else in the agency has?
I do not know the process that has been established by the agency and the staff so far.
Would you please provide to this committee information on whether and who, if anyone, contacted the Fish and Wildlife Service with regard to the possible effects of the two power plant rules on endangered and threatened species?
Well, I know, Congresswoman, that when the rule comes out in final form, you will see this as a comment and response, and it will be fully responsive to your request.
Let me go now to the existing source rule. What's the basis for finding no effect on the manatee under the existing source rule? The overwhelming evidence is to the contrary.
I can't answer that specific question any more directly than I just did, which is the folks are aware of the concern that's been raised, and they will address that concern, and we will make sure that when the final rule comes out, it's consistent with our requirements under the Endangered Species Act.
Would you provide to this committee also the basis for a decision?
That will also, I'm sure, be thoroughly discussed, but I'll make sure that's the case as we look at the response to comment in the rule.
Thank you, Ms. McCarthy. Mr. Chairman, I yield back.
Thank the gentlewoman. I'll recognize the gentlewoman from the District of Columbia, Ms. Norton, for 5 minutes.
Thank you very much, Mr. Chairman, and I want to thank you especially for today's hearing. I think it's a very important hearing. And I want to thank Ms. McCarthy for coming and for the progress the agency has made. Ms. McCarthy, when I became chair of the Equal Employment Opportunity Commission, sexual harassment was not even defined as sexual discrimination. We issued guidelines defining the words sex discrimination in the statute to include sexual harassment, and the Supreme Court later backed us up. The courts have not done the same with respect to unpaid interns. I was flabbergasted, but understanding how some courts interpret the law, to find that some courts have already found that unpaid interns are not covered by the words employees in Title VII of the 1964 Civil Rights Act. That means that the people, the whistleblowers who testified here today, could not receive relief in the courts the way an employee of the agency could under the statute. Mr. Cummings, our ranking member, has introduced a bill to correct this flaw in Title VII. He calls it the Federal Intern Protection Act. I hope that some of the Republicans on this committee who have expressed, I think, appropriate outrage at the harassment that went on here will join us as co-sponsors to this bill. And I'd like to ask you if you would support a bill to add or define interns as employees under Title VII of the 1964 Civil Rights Act.
While I can't speak directly to a legislative proposal, I can indicate to you that EPA strives to protect all of our employees from discrimination, and we hold our employees and our managers accountable.
Now, let me ask the question more directly. Would you have your council look at since there has been repeated harassment of interns, and by the way,
right.
This House and the Senate now, like most large employers across the United States, are replete with interns. This has widespread implications. Would you have your council look at the recently introduced Federal Intern Protection Act and indicate to this committee, to the chairman and the ranking member, whether you would support that act to prevent the harassment of interns in the future? Would you give us that in writing?
I am happy to provide technical assistance on this, and I think, as you know, I personally and the agency would support any effort to ensure that our
I appreciate that, Ms. McCarthy, because I can see that you want to get rid of this issue, and you're right to do so. I wasn't here to hear from the first panel, but I've read their testimony, and I was particularly interested in the testimony of the whistleblowers and of Ms. Kellen of AFGE Council 238. In my own experience at the EOC, I found that employees on the ground can be very helpful, particularly, seems to me, might be the case here, where we're talking about managers. Ms. McCarthy, I can think of no one in the life of an employee, not even you, the head of the agency, that has more power and authority over an employee than the direct supervisor or manager. That's why listening to these employees it seems to me particularly important. And of course, she describes what she calls a serious lack of accountability and transparency. She says that EPA in particular, when a manager has a problem, now that, you know, imagine having to file a Title VII complaint against your manager. I mean that really takes a lot, even if the law covered interns. That takes a lot of gall. That's why proactive action would be most beneficial. She does state, Ms. Kellen, that there are tools and procedures currently to address management issues. So I'd like to look at the existing tools and procedures to address management issues, since that's so far out of reach of the average employee. You have made some progress, and I'm looking at these management issues for even further improvement. And so employees are among those who will always offer suggestions. She says that that it would be helpful to have the GAO conduct a study of what she calls bullying in the federal sector, and she doesn't even list EPA alone. Now, understand that the word bullying here has real connotations. I mean, it may be if you bully a federal employee, that's about all you have to do in order to get your point across, and there's nothing she can do, even if it's a form of harassment. So I wonder if you would support the idea of a GAO study of bullying in the federal sector by management employees.
I would be happy to support an independent look at this. And in fact, Congresswoman, I think we still have work to do within EPA. I mean, every agency has to continue to be diligent. But one of the things we've put on the table is a much more concise and well-spelled-out procedures that managers need to follow, in that employees can count on when these complaints come forward. We need to get that over the finish line, complete the review of the union, because we welcome their input on it. But we all have to keep struggling on this issue, and I am not claiming that EPA is above where any other agency is. Bullying happens at all levels whenever there is a power difference between one employee and another, and we have to constantly be as diligent as.
And it's really that power difference I'm talking about. The agency employee may rarely see you, but will see our supervisor or SES far more often. I wonder, because there was testimony that action by managers has not been fully investigated. Now, Ms. Kellen suggests something called a feedback loop, where employees could anonymously offer their opinions of how managers are performing their duties. Now, of course, that anonymous feedback could be of any kind, and I'm not suggesting it's enough to get some kind of action taken against an employee. But this person who was guilty, it would appear, of repeated instances of sexual harassment, if employees could have anonymously reported that, and if the head of the agency knew that others have gone on for much longer than I've gone, including you, Mr. Chairman. If I could just get an answer.
With all due respect, we're almost 3 minutes over. I just tapped.
Could I just get an answer to this question then?
Sure.
Thank you, Mr. Chairman.
I'll be as brief as possible. We do have an OIG hotline, which is the most direct way for anybody to anonymously raise an issue.
And that's anonymous?
It is, yes. But more to your point, I'm happy to talk to Ms. Kellen about any suggestions she has for how we can proactively address this issue and not wait until it has to go to a hotline.
Thank you for your indulgence, Mr. Chairman.
Thanks. We'll now recognize the gentleman from Georgia, Mr. Heiss, for 5 minutes.
Thank you, Mr. Chairman. I'd like to begin by going back to the topic from my colleague from Wyoming. The U.S. Geological Survey, I'm sure you're aware, has the manatee on the endangered list, and they rely on power plants as a source of warm water during the wintertime. And you had mentioned a moment ago that, to your knowledge, the EPA never contacted the U.S. Fish and Wildlife Service or National Marine Fisheries Service. Is that correct?
No, sir, that's not what I indicated. I said that I have not personally had those conversations.
So who has had those conversations?
Well, the obligation of the development of the rule and addressing those issues falls to, I guess, our Assistant Administrator at the Office of Air and Radiation would be the next one to look at this issue.
You guess, so you don't know who is responsible?
You know, I don't run the day-to-day work of the rule. As you know, we received lots of comments on this rule. This is certainly on the radar screen, and I am confident that we will put out the rule in a way that addresses this.
Well, it needs to be on the radar screen. This is the law.
Absolutely.
The law requires you to
Yes.
contact them, and you don't have any idea if they were contacted or not.
I just said I did not participate in conversations myself. That's all I'm in.
And you're also indicating that you don't know if anyone else did either, because you're saying you guess it might have been one department or another. So you don't know.
All I know is that my staff and I are well aware that we have an obligation to meet the rules under the Endangered Species Act, and we will do that.
Okay, but you don't know if those agencies were contacted?
I honestly don't recall whether I've had that direct conversation. I may have, but it's
I'm not talking
something
about you. I'm talking about the EPA in general. Did the EPA abide by the law?
The EPA has to abide by the law and
Did
the
the
final rule,
EPA
and we
abide
will.
by the law and consult with the U.S. Fish and Wildlife Service or National Marine Fisheries?
I'm happy to get back to you, as I indicated.
So you don't know is the answer.
There are many comments that we receive that I do not follow directly up on, but
So are you
I'm
saying
happy to
yes
follow
or
up
no,
on
or
this.
you don't know?
I don't know.
Okay, that's what I was trying to get to. All right, so you don't know if the law was upheld or not?
I know that the law has to be upheld, and I know that happens when we issue the final rule, which has not happened yet.
All right, well, do you realize that the EPA's proposed rule ultimately is going to shut down a number of coal-generated power plants?
I remember in the regulatory impact analysis, there was an estimate of potential closings as a result of decisions the states might make as a result of
There have been a number of those. One of them is in my own district.
Okay.
Plant Branch was closed down because of EPA regulations and so forth. And this is
What plant did you say, sir? I'm sorry.
Plant Branch in Milledgeville, Georgia, shut down because of the EPA regulations, and hundreds of jobs have been lost because of that. And the Manatee, of course, not in my district, but relies in other areas on the warm water generated here. And it just sounds to me, again, that the EPA is not abiding by the law. What would happen if a business decided that they were just not going to abide by regulations from the EPA? Would you ignore that?
Not if it was called to my attention, and certainly EPA won't ignore the law either.
Well, EPA has been ignoring the law, and it's not. Do you believe that all coal plants should be shut down?
I don't, it's not, there's no belief system I have about coal at all, sir.
You don't have a belief
All I do is
system?
enforce the law.
Do you believe that coal generates power?
Yes, that's a factual issue.
It is a factual issue. Do you believe that they should be shut down because they're coal generated?
I think they offer tremendous value to
That was not my question. I know they offer
No, I don't
value
have
because
any
they offer
belief as to
energy.
whether they should be shut down or not shut down. I don't, that's not a belief system for me, sir. I appreciate the value that coal brings to our energy supply system and how
You're
valuable
having a
it is.
difficult time understanding my question. I'm asking, do you believe that coal plants should be shut down?
I have no such belief that they should be shut down. I
Okay.
have no belief.
Are you aware that EPA policies and regulations are skyrocketing the ability for coal-generated power plants to exist?
I believe there are two things happening. One is there is a transition in the energy world, and coal is becoming less competitive because of inexpensive natural gas, and I believe that we are putting rules out.
Coal is
that
becoming
are
expensive
related to
because of
pollution
the
from those sources.
upgrades that are required by plants to uphold the regulations put upon them by the EPA. My time has expired. I thank you, Mr. Chairman.
Thank the gentleman. We'll now recognize the gentleman from Alabama, Mr. Palmer.
Thank you, Mr. Chairman. Ms. McCarthy, Arthur A. Elkins, the Inspector General for the EPA, testified a number of times about their frustration with cooperation from the EPA. As a matter of fact, he talked about how the EPA had inappropriately blocked his office from conducting some investigations that involved employee misconduct. He testified to this in September 2014, and in that testimony advised the committee that the EPA had asserted that there was a category of activity defined intelligence to which the OIG may have access only subject to the EPA's granting permission. He further stated that in some cases the EPA's obstruction had interfered with and in some cases fouled the investigations. There's other testimony by Patrick Sullivan from the OIG's office where he talked about other inappropriate activity taking place at the EPA in which employees, the EPA employees in the Office of Homeland Security had been interviewing EPA employees and telling them not to tell the OIG pulling EPA employees' emails and phone records and searching information on employees' computers, among other things. And he said those, in fact, are investigations, and that's what they're doing. And the point is that the Office of Homeland Security doesn't have investigative authority. Now, this has gone on now for some time. In April, Mr. Elkins testified again and pointed out that the EPA had confirmed to the Office of Inspector General that it would share the information that they had been seeking, both with regard to previous matters and on an ongoing basis, and that the agency had not yet shared that information. Then in June, apparently, and I do want to cite one other thing, there was a memorandum of understanding that the EPA entered into unilaterally with the FBI without informing the OIG that further impeded the OIG's ability to do their job. And then earlier in June, you finally agreed to turn over the information, and you also said, informed the OIG's office that you had rescinded the memorandum of understanding. Now, my question to you is, have you turned over all of the information from the investigations from the Office of Homeland Security?
My understanding is that we have made tremendous progress.
No, ma'am. This is a yes or no answer.
I'm trying to answer your question, sir. I do not believe that we were withholding information or that MOU indicated that we would be. However, I've addressed every one of Art's concerns, including rescinding that MOU, having direct contact with the staff, reaching an agreement with the FBI on how to integrate the OIG into all of the efforts that they're concerned about at our Office of Homeland Security, so that Homeland Security can perform their programmatic functions and never, ever be reviewed by the IG or anyone as above the law in terms of allowing the IG access to information they need to do their job. We've made great progress in that venue.
Well, you keep talking about not impeding the OIG's investigation, but that's not their opinion. In this April testimony, you said in this particular case, the OIG's investigation was negatively impacted and delayed by the fact that these senior EPA officials did not notify the OIG about their knowledge of the underlying incidents. And my question, again, have you turned over the information from these investigations to the Office of the Inspector General?
I'm not sure I understand what this refers to, sir, but I do not want you getting the impression that we're withholding any information that the IG needs to do its job.
Reclaiming my time.
I think the IG understands
I'll simplify it for you. Let me make it simple.
Okay.
Have you turned over all of the information from the Office of Homeland Security to the OIG?
As far as I know, the IG and the Office of Homeland Security are working collaboratively to ensure that the Office of the Inspector General can do its job while the Office of Homeland Security can perform its programmatic
The reason I'm pressing
That's how it's supposed to work.
The reason I'm pressing this is throughout this period of time,
yes,
you consistently offered to work with the OIG's office and didn't do it. Okay? So I just want to know, are you going to do what you said you were going to do? And I appreciate the fact that you rescinded the memorandum of understanding.
Thank you.
But we would like to know definitively that you are turning over the information that the Office of Inspector General has requested, and if you have not, when will it be done?
I have dictated that as an absolute requirement of our Office of Homeland Security. We met with the Federal Bureau of Investigation. We set up a process to ensure that's happening, and I have heard no further concern of the Inspector General that information that he is aware of is being somehow withheld.
Okay, we'll follow up on that later. If the Chairman will indulge me, I have one other question. 5 years ago, armed agents from the EPA conducted a raid on a city wastewater treatment facility in Dothan, Alabama. What I would like for you to do, Ms. McCarthy, is provide to this committee a copy of the threat assessment that justified armed agents and body armor conducting a raid on a municipal facility. Mr. Chairman, I appreciate the additional time. Thank you.
Thank you. As we wrap.
Mr. Chairman, can I just make sure I know which incident he's talking about? I'm aware of an investigation. I'm unaware of any raid.
Okay. It's the city of Dothan, Alabama.
Okay, thank you.
Thank you very much.
We would appreciate your following up with Mr. Palmer on that. I appreciate
Okay.
it. As we wrap up here, I have just a few sort of cleanup questions here. Can you provide this committee the bonuses, if any, that Mr. Paul Bertram received over the last 10 years?
I'm happy to follow up on that, sir.
And Susan Hedman, could we also look at those for the past 10 years as well?
The regional administrator?
Yes. Bonuses for the
Certainly.
last 10 years? We would appreciate that.
Okay.
She was the person in charge with all of these incidents that we've been talking about, the sexual harassment incidents, not the other issues that were sort of off topic. What's your assessment of her performance in this?
In this instance?
Regarding the sexual harassment issues, the retaliation, et cetera.
I do not know what her direct involvement has been. I'm aware of the full record, and I know that the employee in question was basically left federal service, which I think was the appropriate thing to do. I do not know her direct involvement in the retaliatory issues.
And I guess that's the concern. I mean, it's risen to the level that we're having congressional hearings about this. We have expressed concern about this. These problems keep happening.
Yeah,
And you know, it's one thing when you get one person complaining. It's another thing when you get three. And their testimony is consistent. Their authenticity seems to be as real as it gets. Our professional staff have spoken to the victim here, one of multiple victims that were at the hands of Paul Bertram. And what's just sick and disgusting is that it was allowed to continue through years. And we brought this issue to you before about when somebody does this and they do look at it, I don't understand why it's not in their record so that the next time they go to get a bonus or a promotion or come to some conclusion that somebody can't look back at this and say, I mean, first of all, you should never get to the second time, ever. But in this case, we're talking about 10 times. Now, I respect the idea that you were not the administrator the entire time, but it is your watch, and you've been there for a few years now. And we had a hearing about this earlier this year. Yeah. What specifically are you doing, not about issuing, hey, here's our sexual harassment policy, which is important, but what are you doing to make sure that nobody, but nobody, is allowed to get a bonus or promotion if they participate in sexual harassment? And are you doing anything to look back into the record and find those people who have a serial problem with harassing women in particular? And it can happen to men too, but the cases we've heard have been primarily towards young, entry-level women. Yeah. What exactly are you as the administrator doing to get rid of those bad apples so we don't ruin somebody else's life? Because the atmosphere that we hear about today, it's still going on. I have no trust or belief that you've actually solved the problem.
Well, you know, we have to be as diligent as we possibly can.
I know, but what is that? What are you doing?
One too many, and I understand that. I want to make it clear to you, Mr. Chairman, that we're not just putting another policy out. We're actually doing an implementation, procedures, so that the employees can know what it is. We can hold managers accountable for actually following those procedures. So we're working through that with the union because I understood that this issue has been raised. But you know, we'll continue to be as diligent as we possibly can. We'll find out what we need to do to make it more comfortable for these women to come forward. This is a very difficult situation that I take very seriously.
I just don't hear the specifics. Here's what I want to hear. We're going to go through each and every personnel file, and anybody who has sexual harassment, we're going to go back and evaluate that. We're going to do criminal referrals where necessary. We're going to fire people who have participated in this habitually. And we're going to go through each and every one of those. It's going to take some time, But we're going to do that. And when it comes to our attention next time, we're going to get the Inspector General involved, and we're going to take it very seriously so that everybody feels comfortable in their work environment at the EPA. That's the answer I'm looking for, and you're nowhere close to that. Did I say anything that you would disagree with?
You have not said anything I disagree with how you would handle it. My concern is making sure that we follow due process for the employees. That is equally important to me, whether you're an employee or you're a manager. I am going to follow due process.
Nobody's going to argue against due process. But what we heard testimony in the first panel is when they went through the due process, we had some brave people stand up and say, you know what, a reprimand ain't good enough here. You're going to have to do something more.
But I want to make clear to you, Mr. Chairman, the managers in that situation absolutely agreed as well. It provided an opportunity during the process for more women to come forward.
That is not true.
That was the decision of the management, was to call for that gentleman's removal.
That is not true, because the original recommendation was to move his cubicle 4 spaces down.
Well,
and hold on. Fortunately, you had some people who came in and said, that ain't good enough, folks. And now they feel like there's retribution. Look, we don't need to rehash the whole case.
No, I just wanted to say I couldn't agree with you more that we have to be serious and diligent. Let me go back and see what else the individuals or the unions would suggest, and we'll keep working through this issue. I just don't want to leave here with you thinking that I don't take these issues seriously, because we absolutely do, and I'm going through not just policies and procedures, but we will do everything we can to follow up on the issues that were raised to you today. Had they been raised to me earlier, maybe we'd be further along, but I respect the rights of every employee at EPA and the unions to come to you or anybody else with these issues, and I will not hold that against them. I will work with them.
I want to believe you. I just want to see the action. And I want you to follow up with this committee. We have jurisdiction over all of the federal workforce. This is something that we're seeing not only at the EPA, but other agencies as well. And I think we need a clear definition of sexual harassment, sexual misconduct, and what are the consequences for that? Because it's happening government-wide, and it's a problem. I do want to ask, last thing about the Inspector General.
Yes.
Do you think it would be appropriate or inappropriate? Do you think it would be appropriate that if you have a sexual misconduct or sexual harassment, to have that automatically referred to the Inspector General's office?
Well, I'm happy to talk to the Inspector General about that, but that's
no. I want you to talk to me about that.
Well, part of that is the discussion of our implementation that's currently happening with the unions on how they want these issues implemented.
Why not automatically refer this to the Inspector General's office?
It is generally, this is not a criminal issue. It is an administrative procedure that goes to our Office of Human Resources.
Sexual harassment is a crime.
But we work with the IG on these issues. We don't exclude them from.
You don't. You didn't in this case. That's the problem. You did not refer it to the Inspector General. You did not refer it to the criminal, to any criminal referral. I would think that you would work with the person who is claiming the sexual harassment and work with her to figure out the proper remedy. She complained multiple times. It's not as if she came forward once. She came forward multiple times.
Well, we don't need to rehash this other than to recognize that we both share the same concern, and you have my assurance.
But you're in a position to do something about it.
And I will, and I have.
But you didn't. You didn't.
Well,
you didn't. We had the conversation earlier.
Yes.
We want to look at making sure. Last question about the IG, still on that same topic.
Yes, sir.
What information does the IG not able to access? In other words, to me, the IG should have unfettered access to the information that it wants. What exceptions are there?
Well, in issues of national security, we just have to make sure that the appropriate individual receiving that information has the appropriate clearance.
Understood.
That's the agreement that was reached, and that's what we operate.
Other than that, the IG should have unfettered access, correct?
I can't speak to whether it's unfettered. I know what my responsibility is to make sure that they can do their jobs effectively.
We've had the Inspector General come before this committee and said that your agency is not allowing them the access to the personnel or the information that they want. I want to know why not, and what they shouldn't be able, who they shouldn't be able to talk to, and what documents they shouldn't be able to see.
I believe we are, but you can speak with Mr. Elkins directly. We have.
I have. Now I'm asking you, what? This should be a simple question.
It is, and I've
Should-
answered the questions.
I don't think so. Should the Inspector General have total access to all personnel and all information?
They should have access that's appropriate for them to do their jobs and
Okay.
has the appropriate clearance.
Why are you
and
qualified?
they have that.
Should they have access? It's appropriate for them to do their job by having access to all the
just don't
personnel
wanna
and all the information.
I'm not a lawyer. I just don't want to have you ask me a direct legal question and me pretend I am one. And I don't want to go down that road. I do not know
When
what
will
the
you
term
provide us an
unfettered
answer?
means.
Can you provide an answer to me? Pick a date. What's an appropriate time for you to come back and answer me that question?
Well, why don't we work with your staff and we'll make that determination.
Give
and
me
I'll
a
do the
date.
best
Give
we
me a
can to
date where
meet
I
that.
say, Administrator, it's past deadline. What's an appropriate date to get that
I
back?
can explain to you, sir, how we've reached an agreement with both OHS and the
I don't want you
IG
to
and
have
the
to negotiate.
FBI.
The Inspector General's, the IG Act is very clear.
I'm
This
sorry,
is
sir.
taking far longer than should. I just want you to give me a date as to when you can respond to me. That's all I'm asking.
I've already responded that I believe we're providing them access to every information they need, and that is already happening. And there is a process for that. I had to protect the interests of the intelligence community. I've done that, and the IG can do their jobs.
Okay. I want you to give me a date as to when you will give me a full and complete answer as to what limitations you think there are on the Inspector General. My opinion, they should have total, complete access to all personnel and all of your records all the time. If there are exceptions to that, I need to know, I want to know what those are. And you said you're not an attorney. I'm giving you time to, I respect that.
Right.
I want you to take some time, get the answer right. We also have jurisdiction over the Inspectors General, so we want to get this right as well. What is an appropriate date? Don't tell me we're going to work with staff because these continue on in perpetuity. Give me a date. I'm letting you pick the date.
Would it be okay if I asked my
Sure.
my attorney what
Ask
an
him.
appropriate date might be?
Yeah.
Okay. Is 30 to 60 days okay?
How about the end of August? Is that fair? By the last day of August?
That sounds like 30.
Yeah. Is that fair?
I'd be happy to do that.
All right. Thank
And
you.
I apologize. I wasn't trying to confuse the issue. I just didn't want to act.
I want you to have
an
the proper
attorney.
time to get to the right answer. So we will say the end of August.
Thank you.
All right. Mr. Cummings.
Just very quickly, just want to clarify some things, Ms. McCarthy, and I'll be very, very brief. It's my understanding that the intern had been, the first time she came and notified anybody of this was in March of 2011, although she had been being harassed at least a year, I guess, earlier. Is that right? Is that your understanding?
I am aware of when she reported it and when the person was removed.
Would that have been March
from
2011?
Service, yeah.
Yeah. And there's been a little bit of confusion because, and I wanted to straighten this out earlier when the gentleman testified, Mr. Harris, because he talked about 10 statements, but I wanted to make sure, as I understand it, based on our review of the witness statements provided to the committee, we understand that EPA Manager Paul Hoverton only knew of one incident of sexual harassment prior to March 2011 incident, although there were we have witness statements.
Yes.
But as far as, we keep talking about
was
the
11
10
years prior to
people being harassed.
Yes.
I don't think that was clear. It's not your fault, Mr. Harris. I meant to clarify that before. But the only thing I would say is this, Ms. McCarthy, I hope that you took the things that I said in the light
I do.
that I said them, that I meant them, and I just want to see if we can resolve these issues. And I thought the points that the chairman and certainly the points that Ms. Norton made were just right on. I mean, we're just some kind of way we've got to be able to resolve these issues and create and sort of memorialize the solution as opposed to rehashing over and over and over again. And that's all we're trying to do. And we want to work with you because I know you were about to tell the chairman that at the very beginning about your own history, about your family, and what you, I'm sure, have seen in your life as a woman being in in all kinds of difficult situations. So we know you have the sensitivity, but now we've got to make sure that we bring all of that to bear so that people like the people who testify before us will feel that they do have an opportunity to get these things addressed. Finally, let me ask you this. I'd appreciate it, and this is just a little personal favor, is that you at least meet the three people and just say hello to them, because they may never get this chance again to meet the top person in the agency that they work so hard for. They're still in the audience. And I hope that you would at least meet them and thank them. Thank you. Thank you, Mr. Chairman.
Thank you. As we wrap up, to the good men and women who work at the EPA, like I said, the overwhelming majority, they're good, honest, patriotic people working hard. You know, God bless you. They're important. There is important work to do. We also know that there are going to be bad apples. You get that many people together, there are going to be some bad apples. We want to work with the unions, with the employees, the administration, with Congress. Let's weed out those bad apples. Hold them accountable. It'll make everybody's life better in every way, shape, and form. And that's the spirit in which we gather here today. And I want to conclude with what I started with to the Administrator. You have made yourself readily available to the committee and to other committees. You regularly testify before Congress, and to that extent, we sincerely do appreciate it. So we thank you for being here today, and this committee stands adjourned.
It's my honor, Mr. Chairman. Thank you.